Good morning, good evening, good afternoon. Let's get us a little bit of law talk. I like my law talk. All right, let's see. We had this one. We're going to talk about it. And, oh, I don't care about that. AdBlock Plus has been updated. And we had a motion for referral to a pro bono panel by Wallace. And we had a, did I download the same thing twice? Hold on a second. I downloaded the same thing twice. What in the thunder and tarnation? Let's look. We must have downloaded the same thing twice. That's 40 and that's 30. What? Okay, I'll have them both up. We'll go over both of them, I guess. Open with Google Chrome. All right, so that's 40, that's 30. And then we've got an order that we're going to look at for our good buddy, and that's him. All right, and then we have Decastro versus Wagner, where you're supposed to have a motion for reconsideration. A motion for reconsideration. Interesting. So in California, you have 10 days for a motion for reconsideration. So I think he's talking about FRCP Rule 60. Anyway, I guess we'll get there. All right, so let's start at the beginning and work our way to the end. This is going to be a late night stream, so everybody get naked, grab a frosty cold beverage of your favorite thing. This happens to be Diet Pepsi because I got way too much shit to do to get drunk tonight. Or maybe there's bourbon in there and you'll never know. All right, so we need to present share screen. We're going to start off at the beginning. I'm looking at this one, so we're going to share that. Like this and like that and like that, y'all. And we're going to make it bigger. Waka waka. All right, so this is Wallace's unopposed request for referral to a pro bono counsel. Now, on my Discord, there is, I put a link, and I'm going to have to remember what the name of it was, but it was a Ninth Circuit pro bono Nevada, and it was something like the, here we go, LACSN pro bono program. So before we jump into it, let's give this a little looky-loo. We're going to share this tab instead. This is what he's shooting for. He wants to get access to this. This is the Legal Aid Center of Southern Nevada. So there's a bunch of cases. There's a bunch of cases that they have that they're looking for placement on. All these urgent cases, former inmate. All sorts of fun stuff. So they got lots of things where they're looking to get a attorney to take pro bono. They offer you some. They tell you, you can get trial experience. This is going to be great for you. You can learn new fields of practice. Hand pink waving. I miss Coded. He needs to come back soon. I'm addicted. I'm a Coded friend addict. But anyway, so they'll give you malpractice insurance while they're doing it. So, but the thing is that there are, here's the orders. That's the one. That's one. Is this one with the rules? All right. So referral to the program. You guys can see what I'm saying. Yes, you can see what I'm saying. So the court's gonna look at some various things. Is this the right thing? This is not the right thing. All right. Well, let's go find the right thing then. Do 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 do. Boom 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 boom. Am I in the wrong spot? Where is it? Where is it? There is the federal court's order. Where did I find it? Here we go. There it is. Aha. You just have to be smarter. And that's where I fail. It's because I'm not smarter. I'm just prettier. And I'd rather be pretty than smart. So what the court is going to look at to refer someone to a program is the court's going to look at the ability of the party to retain counsel by other means. So I've talked about this before, but the ability of a pro se litigant to get an attorney to represent him in a 1983 lawsuit, if the lawsuit has merit, is probably pretty high. Now, it's different for a prisoner to get an attorney to retain him on a 1983 lawsuit. It's a little bit harder because while there is an attorney fee provision in 42 USC 1985, that means that the attorney is working on the possibility of maybe no recovery. And so the problem with prisoners is even if their rights are horribly violated, what are your damages? How much money are you going to get? A lot of auditors have been confused and misled by settlements where there's some minor inconvenience, like you get arrested, hauled off to jail, and then released on some complete bullshit stuff. And they think, oh, it's $1 million case because Joe Bob so-and-so settled the case just like this for $20,000, $40,000, $50,000, somewhere in that range. Well, the difference between a settlement and a judgment, how much money you're going to get at settlement versus how much money you're going to get at judgment, is that the other side's going to be factoring in, number one, the uncertainty of a trial, how much money a jury might give you, and number two, the actual cost of the litigation. It's expensive. Lawyers are expensive. I mean, if they're working on your case, it could burn up a lot of hours. I worked on an appeal. I finished it yesterday and I filed it this morning. That appeal, I probably put in 12 hours yesterday on the appeal just by itself. That was just yesterday, 12 hours. So I probably in total put in about 40 or 50 hours on it, just on an appeal on a relatively minor case that is probably going to, well, I'm representing the responding party, not the appellant, but that's like 40 or 50 hours of work for a case that, I mean, it probably wouldn't even generate an opinion. So these things are expensive. So number one, they're going to look at is the inability of the pro se party to retain counsel by other means. Can Floyd afford to buy an attorney? Can he afford to hire an attorney? Is it a case where he should be eligible for damages and get an attorney on contingency? So those are the things they're going to look at. The potential merit of the claims. The potential merit of the claims as set forth in the proceeding or in the pleading. So the court's going to look at the complaint, and you can look at a complaint if you've been a judge for a long time. I mean, as a first-year family law attorney, I'm able to look at a lot of these complaints and be like, oh, boy howdy, you're not going to get shit out of that. You don't even fucking know how to allege damages, but more importantly, you haven't been damaged. Your pride's been injured, maybe. Like, how much money did Chili lose by being arrested? How much money did Floyd lose by being arrested? They're going to have to prove it. They're going to actually have to show they lost money, and they can't. I mean, it's not like these guys got injured and they have medical bills or anything like that. They're not going to have damages. So the merit of the claims, there's not a lot going on in there. the nature and complexity of the litigation, both factual and legal, including the need for factual investigation, the need for experts, and the overall needs of discovery. This is a little misleading. Most people are going to think, no, you cannot hire me in Texas, but thank you for asking. Most people think that anything that they're in, any legal dispute they're in, is complex. But the court's going to look at it from the court's perspective. Is this a complex legal issue? And a 1983 lawsuit is not a complex legal issue. There's the basic things. Were you harmed? Did they harm you? Like, are they the cause of your harm? And how much is your harm worth? 3 tiny little questions. It's not that complex. The need for factual investigation, not a lot of need. You've got the witnesses who saw it. You've got the body cam video. You've got the recordings. There's not going to be a lot of factual investigation going on. Do you need experts? Not in this case. They're not alleging any medical damages. You don't need experts. And the overall needs of discovery, again, pretty low. You're not going to need a whole lot. The presence of conflicting testimony calling for a lawyer's presentation of evidence and cross-examination. Is there going to be conflicting testimony? Probably not. And even if it is, well, this is, I think, one of the less compelling things, because you're always going to want cross-examination. Delicious. Whether the pro se party has another case pending before the court, and if so, whether counsel's been appointed in that case. Basically, if you get appointed counsel in one case, you're probably going to get appointed counsel in the other case, because some of these factors are pretty dependent on the actual litigant, him or herself. The capacity of the pro se party the capacity of the pro se party to present the case. Like, can the person speak English? If they can't hablo the inglés, it's going to be hard for them to present the case. If they're deaf or mute, they can't present the case very well. The degree to which the interests of justice will be served by appointment of counsel, including the benefit the court may derive from the assistance of appointed counsel. That's like a little catch-all. Like maybe I really want to add, this particular litigant has been filing a lot of motions. He's doing a lot of sob sit bullshit. He wants an attorney. I want him to have an attorney just to cut the bullshit out. That's one of those. Whether reasonable costs and attorney's fees may be recoverable by the prevailing party in the action. I think this is one of those things where if there are attorney fees recoverable by the prevailing party, the court might be more likely to appoint a pro bono counsel, or maybe less likely, depending. I don't know which way this one would actually cut, because if there's attorney's fees and costs that are recoverable by the prevailing party, that means that if the pro se litigant has a good case, he should be entitled to attorney's fees, so he could lay the money out ahead of time and use that money to get an attorney and then be compensated at the end. On the other hand, if you have a pro bono attorney, I don't think you might not be eligible for attorney's fees if you haven't actually laid them out. So that might be interesting. And the degree to which it appears in ADR, this is a alternative dispute resolution, such as a settlement conference may bring about an early, inexpensive, and consensual relation of litigation. So this is can an attorney help the pro se litigant figure out the value of his case and whether or not he should settle the case and what he should settle the case for. That's what this is. And then any other factors, this is another catch-all that are deemed appropriate by the referring judge. So you can see that there's not a lot of these factors that are going to weigh heavily into Wallace's favor. And you also have to take into consideration that in a lot of the pleadings, Wallace has shown that he's familiar with local rules of court. He said, in this Texas case that I was in, there was this local rule. And was he pro bono, or excuse me, was he pro se in that Texas case? Well, he raised it up. The court might have looked, and guess what? He was pro bono. Or he was a pro se, pro per. They call him pro per in Texas, I think. So he has experience in litigation, self-admitted. His pleadings show that he can research cases. He might not be able to understand them or research them well, but he can research cases. He understands the existence of local rules and how to read them. He understands the existence of the federal rules of civil procedure and how to read them. That's what he's evidenced in his pleading so far. So it doesn't really look like he has a good a good argument, or he will have a good argument. I haven't read it yet. I've seen a few things, but I haven't read it in its entirety yet. But I don't think he's going to get a attorney. Now, hot tip: I have seen that he doesn't get an attorney, but this was my analysis from the beginning, and this is my analysis still. So we're going to go back to this bad boy, and we're going to read it. So I, plaintiff Floyd Wallace, I'm glad that Chili remembers not to put Chili's name in these when he writes them, moves this honorable court to stay proceedings of this action while this court refers me to the pro bono panel for assistance. I don't know if he was meaning to start a new section or like section 1. Interesting. This motion is made based on the included memorandum of points and authorities, the included request for judicial notice, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of the hearing. Memorandum of points and authorities. On May 24th, 2023, I filed the civil rights complaint in this action alleging facts constituting claims for minimally violations of my rights under the 1st, 4th, and 14th Amendments of the United States Constitution. 1L claims due to policies and or failure to train, unequal protection, false or assault, battery, false arrest, false imprisonment, invasion of privacy, and negligence. On July 17th, 2023, defendant Las Vegas Metropolitan Police Department filed a frivolous motion to strike plaintiff's complaint. You know, like I understand like giving a statement of the case, you know, but constantly calling it frivolous. This is obviously not working. Clearly not working. So why do you keep doing it, Chili? I don't understand why you would keep doing that. In that motion, LVMPD alleges that this case is too complex for me to handle on my own, requiring the assistance of well-known constitutional law scholar Jose Decastro, well-known constitutional law scholar. He's a legend in his own mind, to write and file my pleadings in this matter. So they did not allege this case is too complex for you to handle on your own. They allege that you are having Decastro write your pleadings and motions. That's a difference. See, and that's why he doesn't have a citation anywhere in here to what specifically LVMPD alleges. Who has the best winning record, Chili or Merv? Well, I've won cases, so probably me, because I've actually won cases. And even before I was an attorney, I filed a small claims lawsuit against a car repair place, and I won that. So even before I was an attorney, I already was winning cases. On July 26, 2023, I emailed LVMPD's counsel and asked if they would oppose my request to be referred for pro bono assistance or to stay proceedings until we heard back from the pro bono panel. On July 27, 2023, LVMPD's counsel emailed to say they would not oppose my request to be referred for pro bono assistance or my motion to stay the proceeding until we heard back from the pro bono panel. Unopposed request to a pro bono panel. See, like just because they want to oppose it doesn't mean that the court doesn't have jurisdiction or discretion in the matter. The problem with putting bourbon into your Diet Pepsi when it's hot is that you drink it fast. I don't know if my request to be referred to the local pro bono panel will be a request for assignment of counsel under 28 U.S.C. 1915 E1. 28 U.S.C. 1915 E1 allows for counsel to be pro bono counsel to be referred to litigants who can't otherwise afford it. But let's go ahead and read it. People often believe that this only deals with prisoners, but E is not dealing with prisoners. The court may request an attorney to represent any person unable to afford counsel. Notwithstanding any filing fee or any portion thereof, the court may have been paid. So the court would dismiss the case. So if the court requests an attorney represent any person unable to afford counsel, then you have to proceed in forma pauperis. And part of that means that the court gets to look at your complaint and at any time, sua sponte, can dismiss the case if the allegation of poverty is untrue, the action or appeal is frivolous or malicious, it fails to state a claim upon which relief can be granted. That means that even if the other side isn't filing a 12b6, the court can sua sponte kick this shit out. Normally the other side has to bring a motion, but this allows the court to do it on its own. And if it seeks monetary relief against a defendant who's immune from such relief. So if you're seeking money damages against something that is immune to money damage awards, then they kick it out. So that's what he's seeking for it under. But again, there's that local rule. There was a local rule by the Ninth Circuit, by the District of Nevada. It is their amended General Order 2019-07. And that's where they ordered that they're going to do this pro bono operation. Basically like fresh law school grads kind of thing. People who are trying to get their feet under them, get a little bit of experience in the courtroom. You drink hot Diet Pepsi? Well, there's your problem. I don't. There is plenty of ice in there, I assure you. Plenty of ice. Plenty. If so, if this is going to be a 28 U.S.C. 1915, I ask the court to take notice of any well-pled claims and of the video of my arrest that I request judicial notice of. That's not how judicial notice works. Judicial notice allows the court to take judicial notice of things like other lawsuits, other legal actions. Like the court can take judicial notice of the file in another case, or even the file in your existing case. The court will take judicial notice of previous filings. They exist. That doesn't mean the court has to accept them as true, but it'll take judicial notice of them. You don't necessarily have to authenticate them, lay the foundation and authenticate that particular document. Judicial notices for things like maps, like determining that Oklahoma is north of Texas. That's something the court can take judicial notice of because maps exist, and we know. I mean, you don't have to authenticate a map. You know, bring in the custodian of records for Rand McNeely or whatever the hell the map company is. You know, have them authenticate the map. Blah blah blah. You don't have to do that. The court can take judicial notice of maps. The court can take judicial notice of dictionaries. Those are the things that courts take judicial notice of. Anything else, you have to authenticate. If the court's not just going to take judicial notice of it, there's going to be questions, especially in the video of the arrest. I mean, there's going to be questions. Who took the video? Was it edited at all? You know, did it ever leave your possession? Did anybody alter it? Have the settings been played with? The brightness, contrast, this, that, the speed. There's going to be questions. You have to authenticate it. So the court won't take judicial notice of it. But he asked the court to take notice of any well-pled claims and of my video of my arrest that I request judicial notice of for proof of my success on the merits. Proof of my success on the merits. There has been no success on the merits in this case so far. Nothing has been done on the merits. You will go to trial, and the court will make a ruling on the merits of the case, or at summary judgment, the court will make a ruling on the merits of the case. But no, you've had no success on the merits thus far. For evidence of the complexity of the case, I cite defendant LVMPD's own motion saying I'm incapable of managing the complexities of this case on my own. They didn't say that. They said that Chile was writing your pleadings. So again, citation needed, where they said that Floyd was incapable of managing the complexities of this case on his own. My audience has told me ad infinitum, ad nauseum, that Floyd is incapable of doing any of this on his own, as if this is novel, as if I hadn't thought of it, as if they're fucking geniuses for coming up with this. But LVMPD's counsel did not say that Floyd was incapable of managing the complexities of the case on his own. Additionally, the enforcement of Nevada state law in violation of my civil rights is a complex issue. Well, just saying it doesn't make it so. And it's not. It's really not a complex issue. None of that is complex at all. The defendants so far seem to be arguing that they operated under reasonable articulable suspicion and probable cause, yet my rights were still violated. Again, that's a conclusory statement. There is a question as to the constitutionality of the alleged, quote, attempted trespass, end quote, laws in Nevada. Well, that's something that the court will determine, and not you. It's not complex. You're going to say it's unconstitutional. The court's going to look at it and say, you're fucking stupid. Additionally, defendants seem to want to establish that a mask is an element that establishes reasonable articulable suspicion of some vague crime, which no courts have yet established. Well, I hate to break this to Chili, but go back to my favorite case, Terry v. Ohio, which should be his favorite case as well, since he wants to overturn it. But let's look at the things that established reasonable suspicion for Officer McFadden in Terry v. Ohio. Good evening, Merb. You twat. You forgot to change your Dr. Dre wannabe white shirt and dirty sweat-free Merb trucker cap from 3 days ago. I put this cap on specifically because this is an excellent charity and you should donate to it. So I picked this up on purpose. Thank you. But anyway, back to Officer McFadden in Terry v. Ohio. What caught Officer McFadden's suspicion? What gave him reasonable suspicion? Well, there are a couple guys standing on a street corner. One guy would walk up to a window, look in, walk back to the corner and talk to the other guy. Walk up to the window, look in, walk back to the corner, talk to the guy. Walk up to the window, look in, walk back to the corner, talk to the guy. Did this multiple times. Then the two of them walked down and they started talking to another guy. And then Officer McFadden had reasonable suspicion that they were planning to do a armed robbery. So looking in a window, i.e. window shopping, and talking to your friend on the corner is reasonable suspicion. So could wearing a mask be reasonable suspicion? Absolutely. It could be, or it might not be. It's all going to be very context-based. The court's not going to look at this in a vacuum and just say, yes, wearing a mask equals reasonable suspicion, or no, it does not. Wearing a mask in a bank might be reasonable suspicion. Wearing a mask at a costume party, probably not. It's the nuance. You know this is Chili because Chili sees his world in black and white. Black and white. Everything is either good or bad, hot or cold. I mean, there's no gray areas or nothing. Not for Chili. It's all black and white. Finally, defendants know how to oppose my request for pro bono assistance. It's not up to them. It doesn't really matter. And then there's an unopposed motion to stay this proceeding. Due to defendants not opposing this motion, they accept they will suffer no damage or inequity. Probably not. I mean, it'd probably get the case resolved faster if there was an attorney, because all the bullshit filings that Chili likes to do wouldn't be done. Additionally, the importance of the case to civil rights matters for myself and for the public could result in grave damage to civil rights if I fight this complicated matter pro se. Well, unfortunately, it's not a complicated matter. And I don't know how you would damage anybody else's civil rights, because I don't think a lot of people are going to film restricted areas at police stations wearing a mask, generally speaking. The subset of people whose civil rights might be damaged is small, i.e. almost imperceptible. And again, I don't think you had a civil right to trespass. And, Adderley versus Florida, people wanted to conduct First Amendment activities on the curtilage of a jail, i.e. the lawns, the driveways, the areas around the immediate jail building. And under the trespass laws of Florida, the sheriff arrested them. They sued for First Amendment violations, or they appealed, or they raised constitutional challenges to it for First Amendment violations. I don't know if it was a criminal matter or a civil matter. Anyway, the Supreme Court of the United States said that the state, like the owner of any private property, can restrict the use of that property to its intended purpose. And I'm going to guess that area that Floyd was trying to film in was most likely akin to the curtilage of a jail. It's the curtilage of a police station, very akin to the curtilage of a jail. And can you trespass? Well, as long as the state law allows it, sure, attempted trespass, why not? I don't understand how there is a First Amendment issue there. Additionally, I'm only requesting to stay until 4 weeks after being assigned a pro bono attorney, or 4 weeks after denial by the panel, which should not be a long time. So what the panel does is if he gets sent to the panel, if he got sent to the panel, which he did not, then he would the panel would determine whether or not he was financially he qualified. So it'd be the informal pauperis. He'd have to show that he didn't make enough money, yada yada. He would have to cough up his financial records. And if he didn't do it, and they found out that he was actually able to pay, then I believe that there is a way the court could go after him for the money if he was fucking around and found out. The court has the authority to stay the proceedings. The United States Supreme Court has long held that the power to stay proceedings is incidental to the power inherent in every court to control its own document with the economy of time and effort for itself, for counsel, and for litigants. That's a true statement. Request for judicial notice. I request the court take judicial notice of the following publicly available YouTube publications. Again, the court will not take judicial notice of them, which capture the events in this action and should show that my claims have merit. The video also clearly shows the LVMPD pointed a gun at me. These links represent a true and correct copy of my videos of my arrest. So he asks to be referred to pro bono panel, say the proceeding, take judicial notice. So that was the first motion, and then we have the second motion. Nope, that's the order. I thought there was. Here we go. This is 2040. Yeah. Okay. This is the second motion. All right. Same I. Are these the same? They're both 4 pages. They appear to be the same. Okay. It looks like he just filed the same thing twice. I'm going to go with he filed the same thing twice. 4. Yeah, he filed the same thing twice. Okay. All right, so we're going to go do the order then. Here is the order. Pending before the court is plaintiff's motion to appoint counsel or refer him to the pro bono program. Docket number 23. Also pending before the court is plaintiff's motion to stay the case pending that appointment or referral. So maybe the court split it up into 2 motions. So anyway, notice what's not in here. The request for judicial notice, not dealt with in here. Plaintiff represents the defendants do not oppose the request. The motions are properly resolved without a hearing. For the reasons stated below, the motions are both denied. A civil litigant does not have a constitutional right to counsel. Nonetheless, court may request an attorney to represent any person unable to afford counsel. The court will do so in exceptional circumstances. Now, Floyd's case is not an exceptional circumstance. It is a rather mundane, run-of-the-mill circumstance. Guy fucks around. Guy finds out. Guy's not harmed, like monetarily or physically. Guy wants to sue the police. He doesn't have any fucking case. And so he can't get an attorney, but he files it anyway because he's smarter than all the attorneys are. And here we are. It's not an exceptional case. In this case, plaintiff paid the filing fee, see docket number 4, and has made no showing that he's unable to afford counsel. One of the things he has to prove under Palmer versus Valdez and the cases that lead up to it is the ability to pay. Does he have the ability to pay? If he doesn't have the ability to pay, well, that's one thing in his favor. The other thing is that the case has merit, that the case as pled appears to have merit. The court has not been persuaded that exceptional circumstances exist either with respect to plaintiff's abilities to articulate his positions or his likelihood of success on the merits. So afforded and likelihood of success on the merits. Now, here is a giant fucking clue to Floyd and to Chili. The court doesn't think you have a good chance of success on the merits. Now, you're not going to listen to me. Chili's not going to listen to me. Floyd isn't going to listen to me. But there's a reason why attorneys aren't banging down your door to try to get this case. Because even if, long shot, Hail Mary, not going to happen in a million years, but just like the magistrate or the judge could have a stroke while they're reviewing the 12b6 motion and accidentally say granted instead of or denied instead of granted and whatever. I mean, you might get all the way to trial and the jury might all have exceptional diarrhea and need to get out of the jury room as fast as possible. So they just say, fuck it, we'll fine for the plaintiff. You saw the issue of damages. You still have the issue of damages. And even if the jury's like, oh my God, we love you, Chili or Floyd, we love you so much. And we want you to be rich and wealthy and to retire to be drug kingpins in Colombia. Well, there's still the pesky issue of a judgment, a JNOV, judgment notwithstanding the verdict. I don't know why they call it JNOV instead of JNWV, but it's JNOV. It's probably Latin. Anyway, with that, if they give an excess damage award, then it's a motion for JNOV, and they will reduce. The court will reduce it. And if the court doesn't reduce it, then the appellate court will, because he doesn't have any fucking damages. He doesn't have any fucking damages. He's at best, damages wise, entitled to nominal damages. Like, here's your dollar. You were right. Here's your dollar. And then punitive damages are constitutionally capped at somewhere around 10%, somewhere around that. Maybe a little more, maybe a little less. I don't think the Supreme Court has settled on an exact percentage, but somewhere around 10 times the amount of special and general damages, somewhere around there. So if he's entitled to $1 in damages, then his punitive damages would be somewhere around $10 maximum. I.e., you're not going to fucking get rich off this. As such, the court will not appoint, in quotes, because he wouldn't. He would refer you to the, or she would refer you to the panel. The court may refer a pro se party to the pro bono program. Such a referral is highly discretionary and turns on some of the same considerations addressed above, including the inability to retain counsel by other means, the potential merits of the claims, and the capability of the movement to present the case. The court declines to make such a referral in this case in considering the various factors. So denied and moot. No order on the judicial notice. That means the court is not taking judicial notice, by the way, just so you know. And there you go. So it looks like Chili is still stuck in the Floyd Wallace case because the court is not going to award a new attorney or grant a new attorney to Floyd. All right. Moving on to Decastro. What are we doing here? What are we doing? This is Decastro versus Wagner. Decastro has filed a motion to reconsider. Oh, he's done it to 59E. Well, hold on a second. Let's do 59E. I thought it'd be a Rule 60. Okay. I don't think he's asking to alter or amend it. I think he's asking to set it aside. But anyway, be that as it may, the courts these get mixed and matched all the time. A lot of people call it motion to reconsider, and the court will probably look at it under Rule 59 and Rule 60. So I wouldn't worry too much about him, although his motion to reconsider is probably going to be shit. I haven't read it yet, so we'll see. In support of this motion, plaintiff submits a memorandum, points to authorities, yada, yada. Introduction, filed first minute complaint, yada, yada. Classic chili. In general, plaintiff was in a traditionally public forum. Absolutely not. Being inside of a city hall is not a public forum. Just ask the pro se litigants of Stout, Stout, and Stout. It is probably a limited or designated public forum, depending on where you're at in it. So no, it's not a traditional public forum. Remember, kids, your traditional public forum is going to be streets, sidewalks, parks. Those are going to be plazas, your traditional public forums, places that have been open since antiquity for people to gather and speak. Not city halls. Generally speaking, not city halls. It could be, I mean, a particular city hall or a particular section of a city hall could be a traditional public forum just because it's been used in that way for so long. But I'm guessing that this was not that. So his argument, he was in a traditional public forum, exercised the First Amendment right at a time when the city hall was open to the public, at which time plaintiff was arrested without probable cause or warrant. Interesting. City hall is open to the public at that time. That's a novel look at the facts there, Chili. I mean, I guess he thinks that the judge is retarded. Let's, you know what? I want to take a look at the order. Let's take a look. We're going to show this tab instead. Boop, 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 boop. He alleged that the someone said the building was closing, it would be locked after the building closed, but before he was able to leave, Decastro alleges that Wagner approached him and began yelling suddenly to cease and desist. Decastro was then arrested and taken to a booking area. Posted bond. His iPhone was not among possessions. Alleged phone was held. Phone was returned. So he did not include several of the defendants in his first amended complaint. So he doesn't show that he was entitled to be in the building after it had closed. So the judge found that the building was closed. Nor does he allege beyond a single conclusory sentence that the defendants lacked probable cause to arrest him. He cannot successfully assert a Fourth Amendment claim for wrongful arrest because he was, by his own admission, in violation of the trespassing statute when he remained in the building after it closed without the privilege to do so. Excuse me. I'm going to take a brief intermission. Talk amongst yourself. I'm going to refill my beverage, and maybe that will keep me from coughing on gnats for a minute. So I don't want to stand up with and show you all the goodies. So I'm going to remove myself. So enjoy the silence for a few moments. So I was sitting here wondering to myself, I wonder how long people would sit here waiting for me. I wonder if like I just went and like took a nap, got up at like 3 in the morning or something and came back and y'all would be like still sitting here like he's really been fixing that drink for a long time. Uh that would that would amuse me to no end. Yes, those are Chili's own admitted facts. But if you just deny them, and you just say in your request for reconsideration, if you just say the opposite, then it fixes it. It fixes it. That's all you got to do, man. Like does this is lawyering 101, my friend. Even if plaintiff was arrested, even if he was arrested for probable cause, who gets arrested for probable cause? That's a weird thing to say. Man, I was committing probable cause the other day. There's a there's a video I saw of some Twitch streamer gal who she got so upset because she's like, every time I get up, and she has this like planky. I put planky down when I get up, I gain viewers, and whenever I come back, people leave. You like planky more than you like me? Oh, it wrecked her. Oh, hilarious. Sorry, we're getting off topic. So you don't get arrested for probable cause. You get arrested, and the question is, did the police have probable cause that you were committing a crime? Plaintiff raised the constitutionality of the criminal statute applied to chill his rights. Yeah, trespassing. Yeah. You know what? Trespassing, it does chill your rights to fucking trespass, you dumb shit. On September 29, 2022, the individual defendants and the city of Ironton filed a motion for a judgment on the pleadings, ECF number 23, in their favor that would dismiss the First Amended complaint with prejudice. Well, let's take a look. 23. We're going all the way back. And there was a order show cause, vacated, motion, response, notation, response, yada, 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 motion for notation, reply to response, yada, yada, order granting, motion for protective order, response, memorandum, order granting, 21 and 23. Okay, so 21, the 12B6, and 23, the judgment on the pleadings. Okay, so we have two things that we're looking at. So he's only appealing the judgment on the pleadings. He's not appealing the 12B6. Okay. In general, defendants alleged that they had probable cause or qualified immunity, and they argued pleading failures in the First Amendment complaint, in that plaintiff failed to allege facts sufficient to show that he had exhausted state remedies or alleged facts sufficient to show there were policies or training failures under Monell. And I believe that they were correct. On January 13, 2023, after being granted leave to extend his response deadline, plaintiff filed an opposition to the motion. In general, plaintiff argued that there was no probable cause, that there were insufficient facts to show probable cause, and that where there is no probable cause, there is no qualified immunity. Plaintiff also alleged further facts to show he exhausted his state remedies and that an amendment would not be futile. Finally, plaintiff argued that at this stage, the facts must be weighed in the light most favorable to the plaintiff. Well, all right. So let's go to the First Amended complaint. It's this one. All right. At approximately 5 p.m., the City of Ironton employee announced the building was going to be closed and locked. Decastro was not given time to leave the building, and no time did Decastro refuse to leave. At approximately 5:03, so 3 minutes later, Wagner approached. So he wasn't given time to leave, but in his own pleading, 3 minutes later. So he's told to leave, and then 3 minutes later, he was arrested. I don't understand what the problem is. I don't understand what the problem is. He was told to leave. At approximately 5 p.m., a City of Ironton employee announced the building was going to be closed and locked. And then at 5:03, he was approached. Fucking weird. So viewing those facts in the light most favorable to plaintiff, the building was closed, bro. Building was closed. Building was closed. He was, by his own admission, in violation of Ohio's criminal trespassing statute when he chose to remain in the building after it closed without permission or without privilege to do so. So they filed a reply. In general, defendants raised pleading failures of the FAC that plaintiff didn't allege that his phone was searched or that he was exercising constitutionally protected activity when he was arrested, and that he didn't associate a policy with the Monell behavior. Additionally, defendants argued that the Ohio laws applied to the facts constituted illegal trespass by the defendant. Yep, okay. So granted the motion in part dismissing the FAC, but without prejudice. It was without prejudice. Let's double check that. It doesn't say without prejudice, but it doesn't say with prejudice. So that'll be interesting. Okay. Points and authorities. Judgment on the pleadings, fact-based analysis, including probable cause. In assessing the pleadings, we take as true all well-pleaded material allegations. The motion for judgment on the pleadings is granted when no material issue of facts exist, and the party making the motion is titled to judgment as a matter of law. Where this court interpreted the motion as a motion for judgment on the pleadings under 12C and decided there were no material issues of fact for trial, the court made an error of law because plaintiff alleges a lack of probable cause and defendants allege the opposite. See, the real problem is that Chile keeps alleging legal conclusions. Now, he's going to say it's a fact whether there is or isn't probable cause, but it's the sum of the facts that gives someone probable cause. Like, I saw this guy pick up a candy bar and put it in his pocket. And he walked out of the door of the convenience store. Do I have probable cause at that point? Well, I could just say I have probable cause, but that's not going to be enough. It's the facts that you allege. The fact is, I saw him pick up a candy bar. I saw him put the candy bar in his pocket. I saw him walk out the front door. He didn't pay. Those are facts. Those are facts. He had probable cause is a conclusion. It's a conclusion. Although in the Sixth Circuit, the burden of proof for lack of probable cause is on the claimant. I think it's always on the claimant. Yeah. Plaintiff has consistently alleged the defense lacked probable cause. First, FAC paragraphs 10 to 11. All right, let's go to FAC 10 to 11. Uh-huh. He included his fucking video. Jesus Christ. So the court can actually watch that video. The court can rule it's been incorporated into the complaint. 10 to 11. I don't see where he says that they lacked probable cause. What I see him saying is that he fucking stayed in a building after it closed. All right. What were the other ones? 25 to 26. So he just alleges that he just says, oh, they lack probable cause. He doesn't actually show why they lacked probable cause. Like if he could show that the clock in the city hall was wrong, and they referenced the clock in the city hall that was broken, and the clock in the city hall said it was 5:05, but the um, but the real time was 4:38. Maybe something like that, or maybe if, okay, well, actually, this is better. Maybe if the clock said it was 4:38, and they looked at the clock and they said the building is closed because it's after 5, and he said no, you just looked up there, it's 4:38, and they said nope, it's 5. Well, then they'd lack probable cause. So, but again, you got to plead the facts, and he's just pleading conclusions because he doesn't know the difference. And then in his opposition, but it doesn't matter what he pleads in his opposition because there you go. And proof is not required until later stages of this action. Crichton, Ashley versus Crichton. Hold on a second. It's a Supreme Court case. Crichton. What was it? Supreme Court. It was a. Hold on a second. I'm not in case law. Federal courts. Probable cause. Was it a summary judgment case? I think it was. Where is it? Oh, come on. Or was it judgment on pleadings? Maybe it was a judgment on pleadings. Anderson v. Crichton. Here it is. When government officials abuse their offices, actions for damages may offer the only realistic avenue for vindication of constitutional guarantees. On the other hand, preventing damages suits against government officials can entail substantial social costs, yada yada. Our cases have accommodated these conflicting concerns by generally providing government officials performing discretionary functions with qualified immunity, shielding them, yada yada. All but the plainly incompetent, or those it should shield all but the plainly incompetent or those who knowingly violate the law. Police officers applying for warrants are immune if a reasonable officer could have believed there was probable cause to support the application. Officials immune unless the law clearly prescribed the actions they took. Somewhat more concretely, whether an official protected by qualified immunity may be held personally liable for an alleged unlawful action generally turns on objective legal reasonableness, assessed in light of legal rules that were clearly established at the time. The operation of the standard, however, depends substantially on the level of generality at which the relevant legal rule is to be identified. For example, right to due process of law, much the same, but it would bear no relationship. Plaintiffs would be able to convert the rule of qualified immunity that our cases plainly established into a rule of virtually unqualified liability simply by alleging a violation of extremely abstract rights. It is not surprising, therefore establish clear the contours of the right, protected by qualified immunity unless unlawful. The Court of Appeals brief discussion of qualified immunity consisted of little more than assertion of a general right that he was alleged to have violated. The right to be free from warrantless searches was clearly established. The Court of Appeals specifically refused to consider the argument of whether it was not clearly established that the circumstances with which Anderson was confronted did not constitute probable cause in exigent circumstances. So now we're talking about probable cause, right? This is on a motion for summary judgment or judgment on the pleadings. summary judgment. So after removing the suit to the federal district court, the officer filed a motion to dismiss or for summary judgment, arguing Bivens' claim was barred by Anderson's qualified immunity for all damages liability. So before discovery took place, before the plaintiff could prove anything, the district court granted summary judgment. The Court of Appeals reversed, and now the Supreme Court is saying that you should have looked to see whether or not there was probable cause. The previous discussion should make this clear that this refusal was erroneous. It simply does not follow immediately from the conclusion it was firmly established, yada yada, that Anderson's search was objectively legally unreasonable, not factually, objectively legally unreasonable. We have recognized that it is inevitable that law enforcement officials will in some cases reasonably but mistakenly conclude that probable cause is present. And we have indicated that in such cases, those officials, like other officials who act in the ways they reasonably believe to be lawful, should not be held personally liable. The same is true of their conclusions regarding exigent circumstances. What the court is saying is that the judge, in making a decision on summary judgment or judgment on pleadings, has to look to see whether or not the officer reasonably believed there was probable cause. Not whether probable cause existed, but whether the officer reasonably believed there was probable cause. Now, in this case, the court apparently found that there was probable cause. He says the officers had probable cause. So what he's saying is that accepting the facts that Chile alleged in the complaint as true, and accepting all uncontested facts as true, there was probable cause. He was in the building. Building closed at 5. He was there at 5:03. Building closed at 5. You're there at 5:03. That's 3 minutes. You're done. So, yes, you can dispose of things, even where they allege that there is no probable cause. Those can be disposed of at summary judgment or judgment on the pleadings. Where this court interpreted the motion as a motion for a judgment on the pleadings under Federal Rule 12C and decided the facts, this court made errors of law by not taking as true plaintiff's allegations. Like plaintiff's allegation that at 5 o'clock he was told the building was closing and he was still there at 5:03. It was 3:03 California time. Yeah, probably. I mean, he just say that he forgot to set his watch to Ohio time. By failing to find on a sufficiency of the evidence and by acting as a finder of fact without the jury, since probable cause is a fact-based analysis. Yeah, I don't. You're not getting anywhere on that argument, bud. So it's a determination is a fact-based analysis. Defendants have not alleged circumstances which the police officers were reasonably aware of when the plaintiff was arrested. According to your 5 o'clock it was closed, 5:03 you were there. You fucking retard. Here the probable cause was not decided by a jury, yada yada. No genuine issue. Okay, they're closed at 5 o'clock. You were there at 5:03. What else do they need? You were trespassing. Closed at 5. You didn't allege you had some sort of privilege that allowed you to be there after it was closed. A legal privilege. You allege you were notified. You stated that you were informed that it was closing. Show this tab. At approximately 5 p.m., a City of Ironton employee announced the building was going to be closed and locked. They told you it was closing. It closed. You were still there 3 minutes later. Like, I don't even know. The court is not going to consider this pleading in a vacuum. The court is going to consider this pleading in the context of every other pleading, especially the complaint, the first submitted complaint. I don't know why Chili is lying. This is like in your face, like stupid. This is a frivolous motion. If an attorney filed this, that attorney could be subject to sanctions. I mean, technically, Chili could be liable for sanctions too. I don't know if he'll get them, but if an attorney filed this, an attorney would be worried about sanctions because this is a frivolous fucking motion. He's literally lying. He's saying that his complaint doesn't say what it clearly says. He was told he was closing at 5, closed at 5. He was there at 5:03. Done. The moving party has burden of demonstrating that. No, I mean, you were sunk by your own fucking First Amendment complaint. Plaintiff alleges the trespass statute then is inherently unconstitutional because it is used to chill his civil rights. The statute may be void for vagueness or overly broad. Okay, well let's look at this then. Nope. Doesn't mention trespass, void, nope. Overbroad, nope. He doesn't make any of those. He doesn't make a single one of those allegations in here. Not a single one. Let me just skim through it here kind of quick just to make sure that I'm not missing anything. Sorry for this. I just want to be sure that he doesn't actually allege that the trespass statute is void or for vagueness or overbroad. Nope. He doesn't make any of those allegations in his complaint. So, like, this is a loser. This is a fucking loser. Plaintiff now after my fucking First Amendment complaint has been kicked, now I'm going to allege these things. Oh, well, first of all, they're shit arguments. But second of all, you should have done it in your fucking complaint. You idiot. This is just terrible. A party cannot move for judgment on the pleadings until the pleadings have closed. I don't. Okay. So there's an answer. There's an answer. There's an answer. Oh, there's an answer to the amended complaint. So City of Ironton, Robert Fauch, blah, 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 and Pam Wagner are the ones who filed an answer. And the City of Ironton, blah, 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 and they're the ones who are doing the motion on the pleadings. So, again, like, are you fucking retarded? Like, are you retarded or do you think I'm retarded? Or are you just incapable of communicating without lying? I don't understand. I just don't even fucking understand. There's literally 22 on the docket. Right before 23 is their answer. I'm flabbergasted. What was the drinking word tonight? Curtilage. Curtilage was a drinking word. Someone came up with the drinking word. I think it was Ryan. Curtilage, everybody. All right. I say curtilage, not curtilage. That's dumb. Curtilage is the right way to say it. I'm from California. Do it the right way. Lower pleading standards. He points to no legal authority. The plaintiff must set forth facts, right? Well, no, he's making an assertion. You have to tell the court. So he argues. See, this is an argument. This is an allegation of fact. This is an argument. Argues that the city defense should have escorted him off the premises instead of arresting him. The fact is they didn't escort him off the premises. That's a fact. The legal argument that you're making, just like you're making a legal argument that 42 USC 1983 applies, that's a legal argument. You're saying that I should get compensated for this because they violated my rights under the First Amendment, and I have a cause of action under 42 USC 1983. Sorry, my bad. Thank you, potentially criminal, and Devin. Thank you. Again, yeah, I got it. You could just say it once, bro. Once. If I look, then I look. If I don't, then you're fucked anyway. So why even bother? So he made an argument. It's like he says he's making a legal argument, is what he's doing. He's making a legal argument that there was some sort of a legal authority that says that they have to escort him off the premises. A fact is they didn't escort me off the premises. That's a fact. A legal argument is they should have escorted me off the premises. That's different. So again, he's arguing the wrong thing. He doesn't understand what he's arguing. This is a legal contention. Not a fact. It's a legal contention. To state a civil rights claim, you must set forth facts. Yes, not legal contentions, facts that, when construed favorably, establish one, the deprivation of a right, caused by a person acting under color of state law. Right. So, great. Here's a problem for you, though. They should have escorted him off the premises. Are you alleging that is a right secured by the Constitution of or the laws of the United States? Or are you alleging that that's a right secured under the Constitution and laws of the state of Ohio? Plaintiff is only required to plead the facts, not make legal conclusions. But you did make legal conclusions. Plaintiff did plead and did include video evidence of him entering a traditionally public forum. Not a traditional public forum, a traditionally public forum. Oh, so now he was denied a permit and arrested as a result. It wasn't that he was there after they closed. No, it was because he was denied a permit. And as a result of being denied the permit, he was arrested. Let's just fucking rewrite history. I mean, who are you going to believe? Chili or your own lion eyes? Like, really? Come on, dude. Wait. Are you going to believe Chili of today or Chili of when he filed his First Amendment complaint? You know, which Chili is that? The Chili of today or the Chili of September 15th, 2022? And that's a great point. Traditional public forum is another legal conclusion, but not to Chili. To Chili, that's a fact. He's pled a fact there. Excellent point, Jeff. You get a cookie. Not for me, though. You can get herpes for me, but not a cookie. And that this is a policy of the policing organization, either due to a written policy or failure to train. Well, see, you don't even know. You don't even know. You haven't even looked at the policies, and you don't know. So what you should have done is you should have looked at the written policies. Is it a written policy to deny people their First Amendment rights on traditional public forums? You don't know. That's why you're just pleading these generalized statements. Plaintiff further alleges, based on information and belief. So I don't even fucking know. That's information and belief is, I'm just kind of guessing. That his arrest was retaliatory for his exercising his rights, and that evidence of retaliation will be available through discovery, specifically that the trespass enforcement is not content neutral. Content neutral trespass enforcement, boys and girls. So here's the problem. The problem is that Adderley versus Florida says that on a non-public forum, it has to be viewpoint neutral, not content neutral, viewpoint neutral. You're barking up the wrong fucking tree. Moreover, plaintiff's rights were chilled if the actions, if, see, this isn't like, what the fuck is this? You know what? If wishes were horses, then beggars would ride. I think that's the way it goes. Herpes are lizards, right? Right? Herpes are lizards. I'm a member of the Herpetological Association. So they're lizards, right? If they were chilled, if the actions of the defendants would chill an ordinary person of a chill person of ordinary firmness, regardless of whether they actually chill defendants. So I have no idea what he's saying there. The plaintiff's rights were chilled. So Chili's rights were chilled if the actions of Ironton would chill a person of ordinary firmness, regardless of whether they actually chilled Ironton's. If a frog had wings, it wouldn't bump its ass on the ground. Frogs have legs, Captain Clown. Moreover, Chili's rights were chilled if the actions of Ironton would chill a person of ordinary firmness, regardless of whether they actually chilled Ironton's possessive. As long as it's iced tea, I don't like sweet tea. Sweet tea is gross and terrible, and the people in the South should be ashamed of themselves and diabetes. So I don't know what this statement means. What does it mean to chill a person of ordinary firmness? And I don't even know. Based on the claims raised, remember, he only has to plead facts, right? He's only required to plead facts. But now we're talking about claims. Facts aren't claims. Claims aren't facts. Poof. This guy, plaintiff has likely. I'm not going to say that I have pled him, but likely. I've likely stated facts sufficient for claims of fabrication of evidence. I haven't pled it, and I haven't even claimed it, but fabrication of evidence. I'm just going to basically he's shitting out words and causes of action into a fan and letting it blast up on and see what sticks to the screen. Supervisor liability. What the fuck even is supervisor liability? A claim for supervisor liability. I'm just gonna plead a claim of supervisor liability. What the fuck does that mean? A failure to intervene. What the fuck does that mean? What is a cause of action for failure to intervene? Conspiracy. Conspiracy to what? Abuse of power by a jailer. How high was Chili when he wrote this? On a scale of 1 to 10, how high was Chili when he wrote this? Because I can understand a claim of fabrication of evidence would be like a claim of fraud or a that would be like a Fifth Amendment due process sort of violation where, if they're fabricating evidence to convict him of something, I could understand that. But supervisor liability, you have a Monell claim, dude. Failure to intervene. This motherfucker's high as giraffe balls when he wrote this. Conspiracy, just conspiracy to commit what? No one fucking knows. And conspiracy is a criminal term. I guess there could be civil conspiracy, but I here, quote. Who are we quoting? This is from Logsdon versus Haynes. Well, let's take a little peeky poo. Let's check it out. Let's check it out, Shecky. Ostensibly, oh, Control F. Criminal. You're not seeing this? So in this particular case, so normally when you cite a case, you don't cite it for the fact pattern of the case. It's great if the fact pattern of the case mirrors the fact pattern of your case or as close to it as possible, because then the legal analysis the court uses and applies to the facts will probably apply to your facts. That's the point of trying to find a case that is similar to your case factually. But here, in this case, in the fact pattern in Logsdon versus Haynes, defendants ostensibly arrested plaintiff for violating Ohio's criminal trespass laws. However, if instead, as plaintiff appears to allege, defendants arrested him because of the content of his speech, then defendants acted in violation of the First Amendment in ways that should have been more clear to a reasonable officer. Viewing the allegations in light most reasonable to plaintiff, the district court erred in dismissing plaintiff's First Amendment claims. We reversed because plaintiff stated a claim but expressed no opinion as to whether plaintiff will ultimately succeed on the merits. Well, let's look at the fact pattern. Background: active member of the pro-life movement, sidewalk, never threatened or committed violence. Several occasions he crossed the property line. He admits he crossed the property line of abortion clinics to communicate. Accordingly, he's been charged with and convicted of criminal trespass in the past, yet plaintiff claims that he has always treated judges and prosecutors with respect, service sentences, yada yada. 1983, two counters. Public sidewalk where plaintiff protested on that day. He hung a sign on the neighboring property fence, got us enlisted, blah, blah, blah. At that point, plaintiff walked onto CWS and took a sign back from Jackson, thereafter promptly returning. So a clinic patient complained about plaintiff's sign, which was on a neighboring property's fence. And apparently in response to the patient's complaint, Jackson removed plaintiff's sign from the fence and walked toward the CVS clinic with the intention of destroying it. Plaintiff demanded the Jackson return his sign to no avail. At that point, plaintiff walked onto CWS property and took back his sign from Jackson, thereafter promptly returning to the public sidewalk. So this Jackson person is the president of CWS, Cincinnati Women's Service. So she contacted the city police. So they arrested him for criminal trespass because he went on the property to return his sign. And the Court of Appeals reversed his conviction, saying he was privileged to enter CWS. So there has been a finding of privilege. The second encounter, again, public sidewalk. He walked into an adjacent public parking lot, and spoke to the patient through a chain link fence. Following the encounter, they complained for criminal trespass. They placed him under arrest. So one time he went on the property and a court found, as a matter of law, that he had privilege. The second time, he wasn't on their property. So I think we can distinguish between these cases, Sir Chili. This court cited, quote, absent a showing that officers arrested an individual without probable cause, a retaliatory arrest claim fails. That is generally the case. These cases are distinguished by the fact they are summary judgment motions, where a showing of evidence is appropriate. But see the difference between a judgment on the pleadings. Judgment on the pleadings just says, like, look, dude, if everything you alleged is true, and if everything that is uncontested, if all the uncontested facts are true, then you fucking lose. You fucking lose. Summary judgment is if all the facts that we have figured out to this point, like with your discovery responses, if all the facts we found at discovery are true, i.e., if the responses you made to discovery are true, then I win. That's summary judgment. So summary judgment, you actually have more facts available than on the pleadings. The pleadings, judgment on the pleadings is just if everything the plaintiff says is true, and if all the uncontested facts are true, then defendant wins. The court has ruled the plaintiff, by his own admission, in violation of Ohio's criminal trespassing statute when he chose to remain in the building after it closed without privilege to do so. This is false, is not supported by the pleadings. Well, that's weird. So this motion is going to be ruled on by the fucking judge who made the order. So Chili's like, look, motherfucker, you dumbass son of a bitch. You're fucking wrong and dumb. And I'm going to lie to your face. And I'm going to ask you to change your ruling because you're dumb and wrong. And by the way, I am the great constitutional law scholar, Chili motherfucking Decastro. Apparently. Allegedly. To the contrary, the FAC states, at 5 p.m., they announced the city was going to close and be locked, was not given time to leave the building. Oof. 10 to 11. Are we missing something there, Chili? To remind the audience, amended complaint. We're going to look at you again. Show this tab instead. To remind the audience of what 10 to 11 looks like. 11. So he cited 10 to 11, but he stopped there. Wasn't given time. And then at approximately 5:03, which is 11, Wagner approached. Chili was still there. Oopsie fucking doodles. Plaintiff had privilege when he entered, and he did not lose the privilege because, number one, the building was not closed to the public, except that a Ironton employee announced the city was going to be closed and locked. So yeah, you fucking did. And two, he had not been ordered to leave by someone with the authority to revoke his privilege. An Ironton employee announced that the building was going to be closed and locked. Although plaintiff did not have his privilege revoked, I thought you only had to plead facts, Chili. This seems like a legal conclusion that we have arrived at here, sir. If I was a gambling man, I would say that is a legally conclusory legal conclusion, sir. Plaintiff continued to protest for the privilege to remain beyond the normal closing hours to exercise his First Amendment rights. Again, he fucking admits he was there after normal closing hours. Just because you're protesting doesn't mean you get to stay after they close, you dumbass. At no time was plaintiff denied that privilege, except when they slapped the cuffs, the torture cuffs. They slapped the torture cuffs on you, you dumbass. Regardless, yada yada, they have privilege to enter establishment when it's open to the public and unlocked during business hours. Yes, you can enter when it's unlocked, right? And it's open to the public during normal business hours. Yep. That's yeah, you have the privilege to enter. Now talk to me about your privilege to remain. Oh wait, you're not going to. Here, the plaintiff's privilege was not revoked simply from some unknown person who you specifically identified as a City of Ironton employee. specifically identified. You knew who it was. You identified that person as a City of Ironton employee. By the wording of ORC Ohio Revised Codes, I'm guessing 2911.21A1 trespass statute, including the word knowingly, it is clear the intent of the statute is the intent of the statute is to require intent. It's not intentional, it's knowingly. If you know that by your actions you'll be trespassing, you don't have to intend to trespass. You just have to know that you're going to be trespassing if you do the thing you're going to do. You know you're going to do the thing. If that thing results in trespassing, then it's, yeah, that's what knowingly means. If you know you're going to do the thing, like I'm going to take 3 steps in this direction. You did it knowingly. Intentionally is different. The level of intent, the mens rea, is knowingly. Here, plaintiffs did not allege intent, but the opposite. Defendants further fail to allege intent. You allege, Chili, that a City of Ironton employee told you it was closing and going to be locked, and 3 minutes later, at least 3 minutes later, you were still there. Neither plaintiff nor defendants allege that any of the defendants had the authority to revoke the plaintiff's privilege in City Hall. You allege that an Ironton employee does. They have a parent privilege. The defendant's failure to allege authority is the grounds for adverse inference. Isn't it weird that all Chili has to do is allege facts, but everybody else has to allege authority? Isn't that weird? That's fucking weird. But, judgment on the pleadings just means that everything that Chili alleged is true. The court's going to accept every fact Chili alleged as true. And he still loses. Kind of fucking weird. The court must interpret the statute to be constitutional, even if that interpretation departs from the most natural reading. It's kind of weird. 869, huh? I don't want that. I want here we go. So at 852 to 853, we're moving into concurring opinions. So it's not binding on anybody. This is a concurring opinion. And now we're into dissenting opinions. So dissenting opinions are absolutely not binding on anybody. So why we're citing a dissenting opinion, I don't fucking know. But we're going to look at the dissenting opinion for authority. $869, right? 869, 2018, Jennings versus Rodriguez. As to 2 possible interpretations, by one of which would be unconstitutional, the other valid, our plain duty is to adopt that which will save the act. Okay. Moreover, a statute must be construed if fairly possible, if fairly possible, as to avoid not only the conclusion that it is unconstitutional, but also grave doubts upon that score. These legal principles reflect a realistic assumption, namely that Congress, particularly a Congress that did not consider a constitutional matter, would normally have preferred a constitutional interpretation to an interpretation that may render a statute unconstitutional nullity. And that is so even where the constitutional interpretation departs from the most natural reading of the statute's language. So we're citing from a dissenting opinion. So that's pretty cool. He made lawful entry, blah, blah, blah. The search of plaintiff's phone. The court found plaintiff only made a conclusory allegation of his phone being searched. This is false and not supported by the pleading. First Amendment complaint at 16. So we're looking at the First Amendment complaint at 16. Plaintiff states facts sufficient to show he has knowledge and belief based on the SIM card and tray missing that the area of insert was damaged. Knowledge and belief. That's not known. That's knowledge and belief. Same thing as information and belief. But let's check it out. Back at 16. Upon immediate inspection, he observed the SIM card and tray were missing. That doesn't mean searched. And that the area of insert was damaged. Doesn't mean searched. In short, the subject iPhone was no longer usable. Now, I'm dumb. I'm not a phone guy. SIM card, that's the one that lets you make the phone calls. That's not a memory storage device. Because iPhones don't have the memory storage chip thingies. So why would they need the SIM card? Why would it? I don't know, but that doesn't say, that alleges SD card. Thank you. That's what I was thinking of. So SIM card and SD card are two different things. Yeah. So, but he's alleging it, but he doesn't provide any facts. He shows that the SIM card and tray were missing, but that doesn't mean they searched his phone, because you don't need to do anything to the SIM card and tray to search a phone. And the area of insert was damaged. But that doesn't mean they searched the phone. Additionally, the attempt to get a search warrant is an indication of attempt, and the fact his phone was immediately available shows the defendants wish to maintain it as evidence. So yeah, Ironton asked for a search warrant, and it was denied. And then they stopped. What's your point? Further, defendants do not deny having searched the phone, which is grounds for an adverse inference. They don't deny it. They don't deny 16. Well, let's check that out, because we know that on 22 they answered, I'd have to buy it. Oh my God. Log in. You sons of bitches. View document. You cost me so much money. Oh, look, they specifically denied it. That's fucking weird, right? That's fucking weird. They specifically denied it. So it was 16. 16, this part. And he says they didn't deny it, except they did. It's like, what the fuck, dude? State remedies for damaged phone. The court found plaintiffs does not allege state remedies available to him were inadequate. Okay. This is false and not supported by the pleadings. Plaintiffs say the results of the state replevin action as being Wagner said that she had no idea what happened to the phone. FAC at 15. FAC at 15. Doesn't say anything about Wagner said. Oh, 17. 17. So You can't even get that right. Congratulations. Further, plaintiff was not afforded an opportunity to report any damages. Dude, like, this is your first amended complaint. But you filed a replevin action in state court. You could have asserted the damages in the replevin action. You could have asserted the damages at the trial where Wagner handed the phone back to you. You were literally in court for it, you fucking incompetent fool. I wasn't given the opportunity. Except when I was in court. Then you were given the opportunity. Fucking Christ. Like, what do you think the trial on replevin was for? You dumb shit. Sorry. My apologies. It is clear that the state procedure did not remedy the constitutional violation. It's clear that you fucked up and didn't ask for the goddamn damages, you idiot. Additionally, Ross versus Duggan, which this court cited, is distinguishable, and it was for illegal seizure of property and not illegal search. You were alleging, oh shit, you were alleging that they seized your property. That's what an action for replevin is, where you say you have property, personal property, not real property, personal property that belongs to me. And I don't want the value of it back. I don't want damages. I want the actual property returned to me. I want replevin. That's where you give me the thing that I'm saying is mine. If someone has illegally seized your property, the remedy is that they return your fucking property. Additionally, the defendants in their individual capacities do not represent the state. Well, okay. The court also finds that no evidence was presented as to any damages, citing the defendant's allegations in its motion. This is false. When the defendant said it, it is false when the court said it. Well, see, we were talking earlier about judicial notice. And I told you that with judicial notice, a court can take judicial notice of the filings in another court and of judgments in other courts. And the defendants asked the court, this court, to take judicial notice of the findings and the order, judgment, in the state court for the replevin action. I don't know what to say. Leave to amend. He's asking for leave to amend. Okay. Did he include a copy of his nope, sure didn't. Sure fucking didn't. Let me back out of here. Let me just make sure that I'm not missing something. Nope, sure didn't. You know, if he had just filed a motion for leave to amend, he would have saved everybody a whole lot more time and trouble. File a motion asking the court for leave to amend to file a second amended complaint and cut through all the bullshit, dude. None of these arguments are worth a damn. And by basically telling the court that you're a liar and that you think the court's fucking stupid, and then asking for leave to amend, do you think that's going to bias the court in favor of granting the leave to amend? Or do you think that's going to bias the court in favor of denying leave to amend? because this is an area of discretion that the court has. A denial of a motion to seeking leave to amend would be abuse of discretion. So, like, why would you, like, it's like when someone has all the power, you typically want to approach them politely, flatter them, buy them a drink or whatever. I don't need the actual video pork chop. And while I wouldn't care if you posted the link, it doesn't let people post links. So I don't know how to make it let people post links. I would totally let you, but I think it's going to deny it. So sorry. But yeah, so instead of being nice, being polite, being humble, Chili comes in throwing literal shit at the person and then being like, dude, let me file an amended complaint. It's like, Christ, you're a fucking idiot. Socially awkward. Lots of confidence, but socially awkward. A district court should normally grant a pro se plaintiff leave to amend where the plaintiff could possibly cure the defect or the pleading defects by pleading additional facts, even where the plaintiff has not requested leave to amend. Here's the problem. You incorporated the fucking video into your complaint. And the very fucking video shows you being told to leave, you being there past closing, you refusing to leave, and them arresting you after the building's closed for being in the building after it's closed. They gave you multiple opportunities. It doesn't support what you've said in your complaint, but you've allowed the court the possibility to incorporate it into the complaint. So it would literally be a waste of everybody's time for the court to grant Chili leave to amend the complaint. Now, am I saying the court won't do it? The court probably will. Should the court do it? Probably not. Excusable error by the plaintiff. The court will consider documents filed after the complaint as part of the pleadings. That's a very short quotation there. Let's check it out. Forney versus Sider. I'm coming up with that. Florney versus Sider. Let's try just this. .835 F second 878. 835 F second Florney versus Sider. This is not. Sorry for the silence. He's got a bad citation in there. All right, let's try this. Hold on 1 second. 1987. Okay. So Chili's asking, so plaintiff responded to the answer, including two affidavits. So this is an unpublished disposition. Sixth Circuit Rule 24C states the citation of unpublished dispositions is disfavored. So he's citing an unpublished disposition. Well, isn't that fucking weird? Isn't that fucking weird? Here, plaintiff has submitted facts in later documents. Affidavits? I don't know. I don't know if I would consider them to be affidavits. In general, and you know, if a plaintiff lays out contradictory facts, a court can take that into consideration. In general, plaintiff lays out all the facts and presents sufficient facts to raise non-frivolous issues in his filings. He expects to be able to amend his complaint at least a second time, preferably after discovery been completed. Well, I mean, guess what, sunshine? Doesn't look like it's going to happen that way. Yeah. All right. So I guess that's it for that. I got a little bit of time. I'm not going to do too late on here. So Paige Beazle is first. Hello. Hello. Must be the weekend. Not yet. Howdy. Good afternoon. Good evening. Hello. Overturn Turner versus Driver. Howdy to you too, Alan. Hello. Evening. 4:18 a.m. in Nairobi. Nairobi. Hi, Jacqueline. Long time no see. Nairobi's in East Africa. I wonder how you feel about Niger. Any opinion on that? I love Law Talk with Merb. Hello, lol. You Americans are crazy. Why do you keep arresting your king? I don't know. We're dumb like that. 1 denied, 2 denied, 3 denied, floor. Like the Mission 22 hat. Thank you, Bill. It's a great charity. You should donate to it. Donate to it. Not to me. Don't send your money to me to have me donate to it. You should donate to it. Good cause. Rock out with the cock out. The cocks are in bed. 30 butt. I'm nearly 50, you dick. Sorry. Decastro versus Wagner is still a thing? Well, apparently. It's 9:20 here Central Time. Oh, good. I need some brain damage tonight. Well, you get what you ask for. Yeah, get naked. Hell yeah, bro. Laura Logan. Laura Logan. I have been in your Discord for years. Well, but have you been useful there? Hand pink waving. Hand pink waving. Hey, Surrender Monkey. I'll be lurking, working on dinner. So, how do you feel about 1,000 dogs for Chili's life? 1,000 dogs for Chili's life. You know what? All dogs are good dogs. Let me pick the dogs. Would they just be hot dogs? What do you think, Merb, of Chris Cordova in Colorado purposefully getting arrested one day before he gets sentenced by the judge in his other conviction? I don't know. I don't know who Chris Cordova is. But generally speaking, getting arrested is probably not a brilliant maneuver to take. How about that? Anybody hear about this? I've heard about this. I've known about this forever. My whole life I've known about this. Pretty and pantless, also trouserless. I'd pick dog shit over Chili if I'm honest. Like, that's kind of mean, dude. Like, he's a human being. Just because you don't agree with him doesn't mean he doesn't have value as a human being. Do you get a free attorney in a civil case? Only if you get the right box of Cracker Jacks. Is it a good idea to get arrested the day before you're sentenced in a federal court? Generally, no. I'm looking for a pro bono attorney. Got you covered. Bold move, Cotton. Let's see how it works out. Cool. I didn't miss this one. Merb, can I hire you in Texas? No. Chili did mention he needs a toilet roll after police engagements. There is that. I did not hear that. Too much information. It appears that Mr. Cordova is helping the federal judge out by putting himself in custody before his federal sentence is handed down, i.e., they know where he is. He seems to prove the prosecutor's point in the letter to the judge that he uses crimes to, quote, make money. That's only going to result in honest YouTubers having restrictions placed on them. What these people don't understand is if you abuse your rights, they get taken away. No. If they're rights, they don't get taken away just because someone else abuses them. If it does, that means they weren't rights in the first place. If I could take away your rights because somebody else abused theirs, you didn't have rights in the first place. Have I mentioned lately that I love cream cheese? I love cream cheese as well on a nice toasted bagel. Can I move to strike that statement? Chili isn't dumb enough to accidentally write his own name. Nice. Who has the best winning record, Chili or Merb? I have won way more cases than he has. I guarantee you that. He clearly is. Tase Merb. IBS will cause you to have frivolous motions. Nice. Chili always editorializes. Yes, he does. He can't write a pleading to save his life. Not well, anyway. You drink hot Diet Pepsi. There's your problem. I used to date Sue Cisponte. Close to the right spelling, but not quite. Wouldn't Sue be a great name for an attorney? Lol. You lost me at, you know what's wrong. You know what's wrong with bourbon. Sorry, my bad, bro. My bad. It's all good. I love me some bourbon. I'd imagine warm Diet Pepsi could cause a frivolous motion. Question: if FDR came back as a zombie, could he walk? I don't know, but he was a terrible president. Not the worst president. The worst president was obviously Abraham Lincoln. Especially for a male lawyer. Grew up tough that way. The Johnny Cash song. Nice. Boy named Sue. Damn Okies. I'm proud to be an Okie from Muskogee. I wonder if A. You know what? I too wonder if A. My whole life I've been like, A? And then people are like, dude, you're Canadian. I'm like, no, I'm just wondering about A. I'm wondering if A. You know? If A? No merit badges for Chili. Well, that's sad. I wonder if Oklahoma is considered north of Texas to a flat earther. Do flat earthers not consider north and south? I mean, when you lay the map down on the table and it's all flat, there's still north and south, right? Haha, Jeff, you just quoted Johnny Cash. Well done. Well, you picked that up, boy. You're a bright boy. Lol. He would have a zombie wheelchair. Nice. I feel like Side Chat is Chili doing blackface, stamping his feet while Merb is trying to explain we need to feck off, and we sue him as Floyd. Hello, Devin. Good to see you too. I hope you also have a great day or great evening. I am incapable of handling the complexity of tying my own shoes. That's sad. Good evening to you too, Ryan Youngblood. And I'm a white t-shirt guy. I don't like colored t-shirts. That sounds racist. I don't like black t-shirts or green or gray. I like just regular old Hanes white t-shirts, you know. I'm a big white t-shirt fella. And I don't like t-shirts with branding on them. But he is a constitutional schooler. Noted. Crime was afoot. Speaking of twats, I haven't heard from Lauren De Laguna lately. That's kind of mean. Hanging out with Chili is reasonable, articulable suspicion. Nice. I have a confidential connection at Scotland Yard and the FBI, so I've heard. Anybody else want to slap the silly grin off Chili? I don't. Violence is never the answer. I mean, unless it is the answer. But he hasn't threatened you or committed violence against you. So why would you want to do that? I think you should maybe take a step back. Relax. It's YouTube, bro. Time, place, and manner restrictions. That would be the test for a traditional public forum, normally. Subject to reasonable time, place, and manner restrictions. COVID turned the world upside down. Who ever thought that wearing a mask to go into a bank would be required? I know, it was kind of weird. He should challenge subject matter jurisdiction. Nice. Obviously, he would lose. He was the moving party. He was the plaintiff. Chili's black and white changes from day to day. Yeah, whatever he wants is the right thing. Whatever he doesn't want is the wrong thing. Imperceivable. Chili sees the world as one giant Terry stop. Drink every time Merb says curtilage. Don't mind if I do. Is that still the electronic signature for Floyd? I don't know. It doesn't really matter. The person who files it is signing it. So, yay, it's probably Chili. Sorry, I meant curtilage. I love when they argue they can't be trespassed unless they've committed a crime or even better, a felony. I know it's dumb and wrong. And I don't know why. Like, you would think that after enough of them get arrested for it, they'd probably start picking up. Maybe I can be trespassed if I haven't committed a crime, but they don't. Floyd should come here to Wales. We love the BBC here. Yes, the British Broadcasting Corporation is well loved in Wales. I told NASA I was king of the moon already. Can I force Chile to stop being a space cadet? Probably not. Or the clerk split the pro bono and the stay motion as separate docket entries. That is a possibility. I believe I came to that conclusion or that potential conclusion on my own, but yes, that is correct. Drink every time someone looks up curtilage. It's real, but an uncommon word that carries weight. Remember, y'all, Merv offers his expert legal anal wisis and opinion pro bono. Show your gratitude by sticking the thumb up it. I don't really care about thumbs up, bro. Like I really don't care. Like if two people watch this, I wouldn't care. You know, I do this for me. This is my fun time. Typical court, divide and conquer the motions. Nice. Now sorry I'm late. Are we talking about news now future statistic? News now whatever Floyd goes by, News Now Oklahoma or whatever. There's way too many news nows. But Judge, he spent all his money in Thailand. Ladyboys are expensive, so fuck you, buddy. Guy fucks around and finds out is a first-year legal precedent. Nice. Technically, Decastro's sycophants paid the filing fee. Or Decastro's audience who enjoys the content he makes, regardless of whether or not. I mean, a lot of people probably watch him for the entertainment value. I know that most of the people who come into my comment section and post stupid shit about him and how terrible he is and whatever, watch his shit. That's a big ass moth. Merb might be this country's foremost legal scholar outside Decastro. That's a big compliment. Thank you. It'd be easy to afford a lawyer if lawyers didn't gouge so much. Right. Hell yeah, base jury, in my humble opinion. It would be hilarious to see this go all the way to being tried in court and watch Floyd have to try the case himself. That would not be hilarious. That would be sad. Doesn't matter. Floyd will just jump back to Thailand if this doesn't work out. Well, good for him. I mean, Thai lady boys. Everybody loves a good Thai lady boy. I hope that moth or whatever doesn't go in my drink, because that would be sad. Drunk moths are sad. Crazy Chiller Summer Bash 2022 was so great. I miss those days. Nice. They all turned him down over there because he's as broke ass as they are, and he is dim on top of that. Oh, in Thailand? Well, that's sad. The Ironton tour was lit. It would be, Goddess of Truth. Is Floyd Chili's next motion is a motion to reconsider referral to the pro bono panel. I don't know. That would be dumb for them to do. because I went through the elements that the court would be looking at, and he's not, he doesn't satisfy any of them. So, yeah, or many, very few of them. That would make Daryl Brooks look like Johnny Cochran. Curtilage. Oh, sorry. I'm running low. Hope there aren't too many left in there. I'd pay for all of the Jiffy popcorn to watch Floyd go down in flames, attempting to try the case himself in court. It would be a train wreck. But imagine those poor jurors having to sit there and like listen to it. That'd be terrible. Merb's chicken coop is a traditional public forum. Good luck, buddy. Judgment non obstante verdicto. Yes, judgment notwithstanding the verdict. Say the word acquit to Floyd, as in, if it don't fit, you must acquit. And Floyd would say, I don't acquit. I want to continue. Nice. Even traditional public forums have rules. Well, they may. They may have reasonable time, place, and manner restrictions, as long as they are content neutral and they allow ample alternatives. Well, Chile also filed an appeal to stay his criminal case, throwing $500 down the drain. So, yeah, wasting money. He might actually end up being a good politician. Did he really file an appeal to stay his criminal case? Wow. Well, good luck to him. Decastro was doing a constitutional teaching session. Lol, yeah, right. Yeah, that was pretty pathetic. Snack break time. Smoke him if you got it. Smoke him if you got him. If Chile does ever run for public office, his videos are all that his opponent needs to win. Maybe. But, well, I mean, like, people do, like, most politicians that we have in office today are fucking wickedly, wickedly corrupt. So, I don't think people care. I don't think people care how corrupt, as long as the person has the right letter after their name, D for Democrats or R for Republican, the Democrats will vote Democrat, the Republicans will vote Republican. And that's just it. Like, who the fuck cares? But Merb, you haven't contemplated Show's application of the Nope Doctrine to judicial rulings he doesn't like. He's got the W. Probably true. Speaker's Corner in Hyde Park is a public forum. I don't believe that the United Kingdom has the same laws or constitution that the U.S. has. Refill time. Merv is going to have fun. I am having fun. That's a redo. Yay, no adult supervision. Chile's only admitted facts. 1, in building. 2, building closed. 3, asked to leave. 4, failed to do so. Yep. Considering pure recent history of only putting forth the worst possible candidates on all sides, maybe that's what Chile's going for. Galaxy brain move. Yeah. All politicians suck ass. They all should get the rope. PC for trespassing. I agree. Yeah, brother. Soothe that throat. Sounded a tad rough. Thanks. Very soothed. We are a patient bunch. I will wait forever. Statham's Peacoat, why don't you post right now to prove that you would wait forever? Because I don't think so. What type of bourbon? Jim Beam. You know, I'm a simple man with simple tastes. I used to drink Jack Daniels, but then someone said it tastes like bananas. Not like real bananas, but like the fake bananas, like in an hour later. And now I can't taste not bananas in it, and I can't drink it anymore. We's just drive over to your place. All right. Nope, I left. You sure did. Decastro thinks Time, Place, and Manner is a hot new band. Nice. That would be a great band name. Laughing. Dozed off waiting. I was just about there too. You gained 10 viewers while you were gone. Give the people what they want, Merb. Well, I'll be leaving here in a minute, so. He took himself off camera because it would have shown he had pants on. I bet. Nope. No pants. Sorry to disappoint you. But, Chili said the magic words. This is now a protest. Yeah, no magic words. I'm slouching further and further down. I think if anyone has a chance, it's Floyd, not Chili. If Chili doesn't fuck up the motions, which he is. I think if anyone has a chance, it's Floyd, not Chili. If Chili doesn't fuck up the motions, which he is. Wow, I think you're drunker than I am. Chili also said, arrest me. I'll go with you. Nice. But Merb, you haven't contemplated Chili's application of the nope defense. Why spam that? I love off topic. That's one of those hot new stores in the mall, right? Off topic. Orange Combs, I'm here for the pants truthing. Well, you've been truthed. Have we given Chili credit yet? It's something special to lose an unopposed request. No, because the court still had discretion. The court didn't have to give it to him. Laughing. You can't win with pants. That's why I'm not wearing them. You go, buddy. No pants is the way of the future. If no PC, no QI. Qualified immunity. Why the hell would they need QI if they had PC? Good point. Actually, that is a good point. Merb, in the months and months of you reading Chili's documents, do you have a favorite motion theory he's made, either as a constitutional expert or one you still laugh about, reminisce the most? No. I don't remember them, to be honest with you. They're momentary escapes from reading serious legal documents. It was a judgment after the evidentiary findings. Okay, come on, Merb. Don't you know that people are supposed to get multiple warnings before they get arrested? He did get multiple warnings. I wonder if Cholita will learn how to spell judgment. Maybe after he passes the bar exam he keeps promising to take. Does he throw an E in there? Because an E would be the English spelling. Yeah, he throws an E in there. It's fine. He's just using the English spelling. It's fine. It's acceptable. Can someone tell me the name of Floyd's channel? News Now, Oklahoma? Something like that. I want to go look at the video. News Now Omaha. Omaha, that's right. Wait, Omaha's Nebraska, right? Mutual of Omaha. Whatever happened to Mutual of Omaha? I used to love to watch the Mutual of Omaha nature videos. God, those were great. God, I love those. Is that a candy bar in your pocket, or are you just Chili shoplifting? Hi, Michelle. Thank you. You're welcome. How much is Wallace paying Cholita? Will Cholita staple flyers to trees calling Floyd a deadbeat for non-payment of legal fees? He'll try to hammer them in with a hammer and nail, and he'll hurt himself. This is where a paralegal comes in handy. Nice. I've been trained and certified to accurately read a sundial. After the sun sets, I'm screwed. Me too. His pleadings are the definition of mere conclusory statements. Yes, they are. But he thinks they're facts because he doesn't understand the difference. Has Chili ever threatened to sue you? He threatened to sue me. He said that he wouldn't sue me because I didn't have like 4,000. I had like 3,000 or 3,500 subscribers. He's like, I only sue people with 4,000 subscribers or more. So like all these people like, oh, hey, fucking subscribe, right? And I got over 4,000. I'm like, hey, bro, like, what's up? And then nothing. He fucking took me all the way to the gates of ecstasy and then left me there. Just dropped me like a prostitute after he blew load in my face. It was terrible. If the judgment doesn't say dismissed with or without prejudice, is it possible in some states is default without prejudice unless sure. Some states, sure. I think the default in because usually they default to like what's best for the plaintiff. And in federal, I believe it defaults to without prejudice. As the state, I believe, with prejudice. I may age myself. I remember getting the time by dialing XXX1212. He could have used that in his argument. I wonder if that so works. Well, you dialing triple X numbers is between you and God, sir. Unless you're under the age of 18, in which case it's between you and your parents. Yes, Chili has definitely threatened to sue Merb. Yes, he has. Me again. I forgot. I have no idea specifically what Floyd video I'm looking for. Can someone help with that? You are a needy son of a bitch, Michael. It was 3:03 California time, though. Good point. Even if there was no PC, then qualified immunity needs to be assessed. It does. And that's the question for the judge, not for a jury. Chili, and that's the whole analysis I went through, where would a reasonable person or would a reasonable cop have assumed they had probable cause? Chili also threatened to complain to various state bar associations. Also, yes, he did. And weirdly enough, I never got contacted by the state bar about that. So mission 22, right there. He self-incriminated on his incriminated. This isn't a criminal action, bro. He self-incriminated on his own live stream when he called the mayor and got denied for a special use permit. So this is all a moot point. It's not really moot because now it's pending. We'll see if it's moot. Alternative facts, not lies. Spoken like a true politician. The janitor should have hogtied him with a vacuum cord. Well, your fetishes are your fetish. Chitler is so silly. Chitler, because he's like Hitler, because he's gassing Jews. Wait, he is a Jew. So Chitler is like, what are you doing, dude? They even turned the lights out at 5. Big clue, eh, Chili? Yeah, but he was still there till 5:03 because he's not bright. I wouldn't give Floyd the views. Well, I mean, he probably lives on the income from those. I would have liked to see the janitor walk over and plug the vacuum cleaner back in. Oh, yeah, because Chili unplugged it so he can continue the live stream. It's as if he bought a Emmanuel's and then just listed everything from the index without reading the chapters. Too lazy to be so lazy. Too lazy to be so lazy as to use the cheat guide. It's almost like you're using speech to text and then not correcting it when it fucks things up. New AK for Cholito. Jose Maria denied Decastro. It's terrible. Here on answer. There, here an answer. There an answer. Everywhere an answer. Nice. Chili is an effing liar. You think? All of these arguments that he did not make in his complaint or his opposition to the motion for judgment on the pleadings are waived. I don't think they're waived or forfeited, I think would be the correct word. Waived is usually in response to like a constitutional right. Forfeited means you didn't raise it. I don't think they're forfeited. Curtilage. Running out. And is my drinking word. God bless your liver, sir. I'll be ready to drink on the next one. Nice. You can't appreciate the beauty of Chili's nope doctrine. You've said that like 3 times now, bro. Like, relax. It's okay. I get it. Land of fruits and nuts. Cops can get off my curtilage. I'm running out. So it won't last long. He thinks the answer is not good enough to be considered an answer. Apparently, Chili's lips are turning white again. That's terrible. Switch the screen. At least you're not telling me about Chili's nope defense. Thank you. Burb asked if Chili is retarded. Yes, he is. I was being facetious. I don't think he's actually clinically retarded. I think he's just dumb. Switch screen. Switch the screen. Well, they did escort him off the premises just in handcuffs and under arrest. They did. Fair point. It's a shame that no one else in the world has as good an understanding of the law as Chili. I know. If only. Poor old Pam had to retire from the force after all the stress and mental anguish of this Chitler case. It's terrible for her. Plaintiff should get to file a motion to stay the case until his criminal record is resolved. He is presently a fugitive from justice. He has a bench warrant. Unless Chili actually has to pay for his stupidity, it will never end. Probably. But you can't squeeze blood from a rock. Thanks, Em. I need visual aids. As opposed to what? Butt aids? Why? They've already gotten the case tossed. I don't know. Chili making legal mistakes. I am shocked. Face, fuchsia, wide eyes. Policy? Traditional public forum is another legal conclusion. It is. Does Chili live in Crazy Town or on its curtilage? I have about 1 sip left. The police have this little thing called discretion. The Arlington police obviously use their discretion to clearly arrest Chili. I believe my own lying eyes. Discretion is whether or not they are going to make an arrest or not for a crime committed that they're aware of. So their discretion, they can't arrest you if they don't have well, they should not arrest you if they don't have probable cause. Their discretion does not trump probable cause. Woo! Cookies rock. They do rock. I have gotten herpes from you. Ha ha. Is that really a ha ha moment? Or is it a burning, itching flare up moment? Getting arrested for being denied a permit is a policy now, apparently. What kind of cookie? If you have to ask, you don't deserve one. Read some of the comments on these auditors' channels. They seem to always believe what they tell them over what they actually show on their videos. Yeah. Read some of the comments in the anti-auditor channels. They also believe what the anti-auditors tell them over what is actually in the videos. Welcome to humanity. Did you bring enough herpes for everyone? Always, sir and or madam. Content neutral. Sounds like a woke Cali term. I know. Do you think he means as applied instead of content neutral? I don't know. He's not smart enough for me to be able to predict what he is or isn't thinking. We will have some evidence sometime in the future after discovery, probably, maybe. Yeah, I know. It's bad. Merb, have you ever considered that Chili might be the one writing these motions? Okay, I may have written that knowing that I'm the 100th person to suggest this despite your own allegations. Thank you, Jamie. If a frog had legs, it wouldn't bump its ass on the ground. Many herps here. Nice. Geckos. Yeah, duh. Herpetological. They added T to it to distinguish themselves. You can be a member of both herps. Thank you. On the subject of wishing, my dad used to say, if we had some eggs, we would have had some ham and eggs if we had some ham. Your father was a deep thinker, a wise man, a prophet. He fucked that up and meant plaintiff, I think. You think? I've heard it is legs. Well, you heard it wrong, Captain Clown. Morning, evening. Sweet tea promotes diabetes. It does. Hi, according to Asa. I stick a cake in the refrigerator to chill. That's a good plan. Chili wrote this after 3 bowls of chronic. Only 3? If it doesn't crunch, it's not good sweet tea. Ugh. Every once in a while, like if I go to McDonald's because they offer sweet tea and regular unsweetened tea. I don't know why I have to call it unsweetened tea because one is sweetened, the other one is not sweetened. It's not unsweetened. They didn't take the sweetness out of it. It's not unsweetened. It's just not sweetened. Yeah. But after ordering an iced tea, sometimes they give me a sweet tea. Chili is like the living embodiment of the Mad Hatter. No, he's not. Not even close. Whatever that is didn't render. OTVO. Nice. Sweet tea can be as good as the maker. It's never good. Thinking. 99. 109. Up to your knees. High as giraffe balls was the correct answer. Possibly, slowly, carefully, lazy, happily, sadly, eagerly, anxiously, gracefully, loudly, softly, briskly, gently, roughly, clearly, sharply, smoothly, cautiously. Thank you. 69. 69! We're doing 69 here, folks. 8. 20. To not recognize the imagined greatness of the failed Power Ranger. He didn't fail. I'm thinking 8 ball. Nice. He's delusional, so it doesn't necessarily need to be too high. I think the dude smokes a lot of bowls. 3 bowls worth. 420. Conspiracy to commit a conspiracy. Nice. They failed to intervene in them embarrassing him. Nice. More than 420. He's a lightweight, so probably 1 bowl. Really? Is he? Oh, I'll defer to your greater knowledge and experience. Peeky Poo is my favorite segment of the Merb shit show. Everybody likes a good peeky poo. Chili prefers the powder. Well, maybe. 8 ball plus 420. Chili's attempts to prove lead poisoning isn't going well. He was smoking 5 paper joints. I injected 5 joints. Chili is on to crocodile. Chili claims he can't smoke anymore because of his tooth, so maybe he a bad trip on some mushrooms. Really, does he claim that? Crocodile. Chili can't smoke because he has a high knee pressure. Boy, I hate that high knee pressure. Morning from Europe. You're wearing a Texas shirt, but you're in Europe? Interesting. Intradasting. Chili's childhood home had lead water pipes. That's terrible. Morning. High enough to make his lips white. Lead flatware in the silverware drawer. Knee-high back pressure. If they show the original video, he says he isn't going to leave. That's why he got arrested. Also, he told the police, and I quote, "Is low to see your dungeon." Pewter dishes, his nostrils death white. "I would love to see your dungeon." Well, gotta buy me dinner first. Even high, Chili is still not over 2 feet high. Small little beta. Pewter is food safe. I'm going back to sleep. Have fun, you lot. Thing that didn't render. You have fun too, Isa. Tire weight suppositories. Nice. My jackboot pig thug landlords are trying to install free air conditioning. I'm only wearing socks. Can someone send me mittens so I don't look like a twat? Well, mittens would help. If Chili was a stripper, does that mean he could do blow off his own ass? Nothing is better than doing blow off a stripper's ass. Crayons have vitamin decastrated. Decastrated. He doesn't have testicles anymore. Yeah. Get him! Oh, he's privileged. That actually looked like it was a half decent ransom note when highlighted and without reading. Chili DeGrifter, loves to sue people because he thinks he's a great lawyer. Lol. I use the same argument at Target when they won't let me stay overnight. And roller skate with Jennifer Connelly. Dude, I had such the crush on her when that movie came out. Oh, her riding that little rocking horse thing. Oh, you know the thing. Come on, man. They seem to think if a building is accessible to the public, they can go anywhere they want and do anything they want simply because they have a camera. Yes, cameras don't grant you extra rights, unfortunately. That failed and totally flawed lawsuit was filed by fool Jose Maria Chili Decastro. Good night, everyone. My butler is ready to give me my candlelit sponge bath and a warm milk enema. Sounds sexy. Time, place, and manner. Closing is a time. What? Who's they? Chili must be using the quantum grammar. Nice. He himself called it a sit-in protest on his own live stream. He shit where he eats. Never shit where he eats. The most amazing part of all of this is that Chili still has a lot of supporters that still think he knows what he's talking about. Does he? Or does he have a bunch of hate watchers who watch him because? The people who make that argument. I think he meant the tiny hat people. That's anti-Semitic. Or like Quantumania grammar. You know, Chili watches these while screaming into his phone, telling Merv how wrong he is. Chili used to send me voicemails and texts and emails. He doesn't anymore. I think he's over me. I think we've broken up. We're no longer a thing. Chili, I would still let you be my power bottom. I don't know how any tiny hat. I don't know any tiny hat people personally. Specifically, I was referring to the fake 1-8 quote auditors end quote. Is there a reason Shelley doesn't invite you to his channel to worship his genius while reading Scholarly Brilliance? Probably because he doesn't like me anymore. Because I'm bad. SD card. Right, it's not memory. Sorry, it should have been rodent. A SIM card is just an account identifier for the phone. Correct. iPhones have SIMs, not memory cards. Not conclusive, but they probably did fuck with the phone. Or they removed the SIM card to prevent him from accessing the phone to delete it? Huh? Maybe they didn't want him to remote access the phone to delete everything off of it? Maybe? Could that have been it? I don't know. Because I think you could do that with an iPhone, but I don't own an iPhone, so I don't know. He can claim they were interested in his contacts. Are the contacts saved on the SIM? I didn't think they were. That sounds wrong. With SIM card removed, the owner of the phone cannot erase the phone remotely. Akbar J Money Grip knows what I'm talking about. My man. iPhone SIMs are now built into the phone. No more trays to remove them. If you need some singles, show us the goods. I show the goods for bills larger than singles, sir and or madam. First year family law doesn't cover the Pacer bill? Tragic. It does. It does cover it. I do just fine. Thank you very much.
SIM card just has a number that ties the device to a cellular account. Some people think the SIM card has all the data on it, but it doesn't. The phone does. That's my understanding. Attention to detail is not Chili's strong point. That's true. I can't help laughing knowing how mad Chili is watching Merv's videos on him. Probably. Chilita to Merv, you're a dunce cap, bro. Except I've been wrong every fucking time, and Chili's been wrong. Or I've been right every fucking time, and Chili's been wrong every fucking time. SIM has a small amount of user storage, optionally used for contacts and or SMS. Okay. If the judge doesn't reconsider, they are clearly corrupt. Imaginary intelligence and lying doesn't make a scholar. What's your point? True, the newest ones like iPhone 14 no longer have accessible SIMs. They have eSIMs. No, it isn't. Your rooster and the hens get apart in your daytime videos. The fish should finish your nighttime videos. It's loud in there. Did I say there was a point? My mistake, there is no point. Not on iPhones, maybe Android. No, that's why I asked. Not only was the building closed prior to Chili's arrest, he said on his old loud enough gear thighed present to hear, including security, that he wasn't going to leave unless arrested. I remember that. How many videos have you seen where officers let the offender hand off their phone to someone else? It's pretty common, but they don't have to. You need to do these by the fish so they can help calm you as you read through his BS. It's loud in there. I have a lot of pumps, a lot of air pumps, a lot of water pumps, a lot of water flowing. And I don't want to bring my computer in there because there's a lot of moisture in the air, things like that. Words are hard. Understanding words are nearly impossible, some say. Chilito also said on live stream after he was released from the dungeon that he was going to delete his phone's history through Apple because there was whistleblower info on the cops. He did not, probably because they removed the SIM card. Say something. I'm giving up on you. That's a song. It's a gay ass song, but it's a song. So I think you're saying Chili will definitely win this one. Absolutely not. It wasn't whistles that Chili was blowing in the phone videos he wanted to delete. It was a well-written piece. He will tell his supporters who don't know any better that he won. That's all that matters. Chitler slam dunk. Hail Chiller. Can we post links here? We've been through that. Chitler, ha ha ha, yo, 50N. Chili didn't trust anyone with his phone, just the gun he stole. He gave that to whoever to hold. What video? Being arrested. Mobile device management is a small part of my job. SIM card just has a number to tie the phone to a cellular account and are transferable between devices even without the carrier's permission. Only mods can post links. Chitler's first jock sock video. The more you know. MD posts links. So this is where we end up when Bao doesn't stream Leech Blood. We clearly made poor life decisions. I am so sorry. Bao is way more entertaining than I am. Mods. Yep. I keep calling Tucson checking if they got Bao. If he actually filed like you had instructed, it would have been too much like right Merb and wouldn't let Chili do things out like he has done. Okay. It is what it is. Stay strong. Commands. Bao. Bao. I haven't heard that name in a hot minute. Chili doesn't like to be told to do anything. Chili's own video contradicts his claims. Can anyone be as dumb as Chili, or do they need to be special too? You tell me. Excusable error by plaintiff. Chili or Chief Wagner says in no uncertain terms, Jose Maria Decastro, you will cease and desist. What error, excusable or otherwise, was there? The error in not complying. What did Bao Win do this time, Ryan? JJ, he's still on the run from DeLaw in hot Texas desert. She even gave him the mom finger. Sounds kinky. Chili looks like an ass yelling at the maintenance man. He replied, we are protesting. It's a dry heat. Good for him. I bet it was a surprise when the people there, it surprised the people there that they were protesting. Probably. He been radio silent since July 31st. I hope that's okay. I heard Bao was joining the soccer team. The fake falling injuries is highly desirable there, allegedly. If Chili had ever gone for a civil disobedience defense, he might have had a chance. I'm not familiar with a civil disobedience defense. but okay. I don't believe that his criminal case was ever resolved. So same old, same old. Yep. The Salty Explorer. I worked in telecom SS7 for years, first in landline, then in mobile, mainly HLR install and support. Time spent nosy equipment rooms has about killed my hearing. Bao is just probably taking a month off. We got to take our content where we can get it, even though Merb is not funny and Fabio's outside. Again, I'm sorry. I know I'm not as entertaining as Bao. Spot on, Aiden, for a Canadian. Does whether or not discovery has happened affect the ability to amend a complaint one way or the other? You have until, generally speaking, you have until they answer the complaint, or else you have to ask for leave to file. So, generally speaking, discovery happens a long time after they've filed their answer. So, usually, filing an amended complaint is cut off long before then. Tinnitus is real. If Chitler says they facts, they are facts. That is for certain. I hope Mission 22 liked their debut live stream. It was pretty epic. I hope so too. Second live stream, Devin. No, I think he's talking about the first one. The first one was pretty spicy. That's a spicy meatball. Sunday was exact same outfit as today's. Well, I mean, it's when your outfit is a hat and a shirt, no pants. You repeat it fairly often. I was referring to the one the other night. Could the judge order him to Ohio to show cause on this frivolous motion? Could the judge? Yes. Will the judge? No. I can't even explain how many times that same question has been asked. Can the judge order Floyd to appear in person? Blah blah. Can the judge? Can the judge? Yes. Will the judge? No. So let it go. Let it go. Let it go. The judge isn't going to do it because the judge, unlike you, cares about trying to get justice. Whether it's not a justice system, it's a legal system, but the judge cares about trying to get justice. And the judge doesn't care about your petty bullshit about ordering people to be present in person. Not that I noticed Merb fashion. You check out my shit. Both were great though. Great. No pants to keep track of anyway. Absolutely, brother. It's easier that way. A is a great band. Okay. Got news for you. Ace Biden is the worst. Like comparing politicians as to which is the worst. No. The worst president ever, though, by far, hands down, bar none, without exception, without even anybody getting remotely close, Abraham Lincoln. I'm sure they enjoyed both streams. Everyone loves Merb's face. Well, that's very kind of you. I pay more attention to his makeup game. You don't like my filter? You don't like my filter? Look how I make my filter blur in and out. It's because I'm using a filter. Maybe it's a Merb. Maybe it's Merbeline. Maybe it's Maybelline. Maybe it's Merbeline. Nice. Slap that bug. Oh, they're all over the place. Be ready. Hurricane remnant due to hit southern central California over the weekend. Batten down any hatches. My hatches are battened, sir and or madam. Curtilage. That's the last one. Sorry. I have drunk. Cholito threatened me with violence, and I dare him to mess with me. Be the last thing you ever do. Well, you're in Europe, dude. Like, you've got an ocean between you and him. You're like tough guy. What's that fat ass name? Irish Demon. Tough guy, Irish Demon. Talking mad shit when he's fucking crossing ocean. Shows up with Turtle Boy. Has a fucking drink. Doesn't say a goddamn thing. Flies back to Ireland and talks shit. Yeah, fucking. If you're gonna say it to his face. Say it to his face. All this keyboard bullshit, say it to his fucking face. Walk up to Chili Decastro. You can find him. Walk up to him. Say it to his face. Curtilage drink. I'm out, dude. Sorry. Ohio's trespass law isn't vague at all. He clearly violated it. Nice. 34th Street. Represent. Curtilage drink. What's up with Earl's appeal? I think he has till the 21st. Last time I heard. Unless they've asked for another extension. 226 watching, but only 79 likes. Well, then maybe they don't like it. You care about thumbs up? No, I don't. Thumbs up my butt, maybe. Lady boys are expensive. That firsthand knowledge. Well, I mean, You ain't lying, bro. Mothra. Does Bao have long hair now? No, don't know. Almost to his butthole. Kinky. Ties it in a bun, though. Obviously he does. You're welcome, Devin. Shitty bun, but still a bun. Easy to grab onto. Curtilage. Hey, Bao. I meant count. Merb doesn't understand the theory and origin of law like Chili. Probably not. Winky face. Nice. It was short the last time I seen anything of his. Actually, it was years ago when he was in jail for a while and he was still kicking it with James Freeman. James Freeman! I have all the archives from this year and last if you want to watch recent streams. Mark Twain said if voting mattered, they wouldn't let us do it. Absolutely. Absolutely. You don't suck ass? Who doesn't suck ass? I mean, like, what's the point if you ain't sucking ass? Hi. Forever and ever. I literally have a crazy fever right now, and I'm still watching you as I die. Ha ha ha. Lol, Jack Daniel. Dude, it does. It does. Taste it. It does. I didn't believe it. And then I tasted something. I was like, God damn it, motherfucker. Baked bananas. You mean like bananas Foster? No, like chemical bananas. Like in an hour, now and later. Pants are for status. Absolutely. Pants are racist. Absolutely. Off topic is where Murr buys his pants. Nice. I like wild turkey. Yeah, it's not bad. Yeah, it's not bad. It's a little strong, but it has a decent flavor. Yeah. E in judgment is like gray. Okay. Tomato, potato. Mutual of Omaha's Wild Kingdom with Marlon Perkins. Great show, bro. And Jim. Yep. Everyone gets old. Not me. Marlon Perkins. I have less than 500 and he threatened me. What the fuck? I don't know. Are you a lawyer? He doesn't seem to like to go after lawyers. I prefer Sagamore for my rye whiskey. I like rye whiskey a lot. Bullet Rye was really good. There was another one that I really liked. I like Bullet Rye. Yo. Cartilage. I'm out. I remember when you were boring. No, you don't. I've always been boring. Cartilage. I'm sleeping out. Going to wake Dad in about 5 hours with my glorious Kiki Carouse. Yeah, about 5 hours, give or take. A great deal of hate for Chili, yet I see him as rather sad and pathetic. Why would you see him as rather sad and pathetic? He is living his best life. He's doing what he loves. He has very few responsibilities. Cartilage. I have to concur. Herpes is a haha moment. It is. Sweet tea or tea? Thank you. Never sweet tea. Never sweet tea. Gross. Working for DOD in Europe, Merb de Beast. Yeah. Okay. Well, you're still in Europe. Don't spoliation my posts, bro. Your comment slipped by me. My therapist told me I'm not allowed to process those type of icky things. Well, there you go. And I was playing a 4th of July show for troops that came back from Iraq in Bamberg, Germany in that pic. Many moons ago. So you're a band geek like Blue Bacon? Do you play the tuba? Or do you play the skin flute? You know what I'm saying? Same here. Jen rocks even now. I'm traveling, not driving. Murma Man. Hey, listen, it's been a while, but I wanted to make sure I let you know that you've been looking rough, my guy. Meds work better than booze for depression, homie. Thank you for your kind words, sir. He is clearly buying his subs. His view count is under 1,500 concurrent, not normal for a 250K channel. Sorry, only just woken. Good morning from the UK. Well, good morning to you. I hope you have a lovely pond in the UK. I shall watch the video now. Well, thank God. I was waiting for you to. I was waiting for that. Man, my day is complete now. You can't argue with stupidity. He's going to watch my video. Nice. Right? It's so obvious. I've seen channels that have around 50K subs that have 4 to 5 times more views on the videos and live streams. He's paying a nickel a sub or some shit. Clearly. Mom finger. Lol, Merb singing it. Let it go while pantsless. Where are the dogs? Love seeing them. They're inside. It's a little warm out, and I'll have to let them out while I close up the coops after this is over. Good stream. Merb won me over with a pro cocaine comment, and Jennifer Connelly orgasm voice. Well, I'm glad I could assist you there. Curtilage. What do you think about Cyrax? I don't like. That dude is sad. I feel bad for him, and why would I make fun of him? I mean, that dude has to live his whole life as that dude. That's fucking terrible. I'll be back in Texas soon. Promises, promises. I'm sure they don't want Europeans back in Texas, by the way. They'll probably tell you to kick rocks. I don't live in Europe. Well, you said you were in Europe and you're talking shit from Europe. Yep, Irish Demon didn't live up to that. That dude is a fat fucking bitch. That dude is a fat bitch. Hold on a second. Do I have a picture of him somewhere? He's a funny looking fat motherfucker. God damn, he looked hilarious. Oh, I'm looking. I had a picture of him around here somewhere. I must have deleted it. I must have deleted it. That dude's a tubby fucking ugly bitch. Not that. That isn't it. What are you? Nope. Is it in this folder? Oh, I don't have it anymore. God, he's a fucking funny looking motherfucker. He had no nose. He had no fucking nose. Let's do this. Because I don't care anymore. I just don't care anymore. Whoa. I'm going to have to go to bed soon, though. But we are going to do present. Present. And then I want to switch to this. Look at this fucking sex god right here. Look at this fucking sex god right here. That is Irish motherfucking Demon. God damn. He's so fat, it swallowed his nose. The fat swallowed his fucking nose. The fat swallowed his nose. Jesus fucking Christ. Music Biz Marty is the king of Akron, Ohio. Nice. Yep, Irish Demon didn't. Lol, that's funny. This one time at band camp, ooh, show pictures. Nah, I play the guitar, right. Merv is on fire. Fire! Mia Sarah looks better. Don't know who that is. Rip Foodie Beauty. Demons don't need no nose, especially the Irish variety. Whoa. Bedtime crew represent. Can't unsee that. Thanks a lot, motherfucker. I know. Like, this motherfucker was huge. I hear tell that he had a gastric bypass, and I can believe it because this motherfucker was a big motherfucking dude. A big dude with a little dog. I mean, he fills out that hoodie. He fills that motherfucking out. Oh, you can't see it. Hold on a second. Like, look at those fat thighs. I mean, that is not the kind of dude you'd expect to go out and be knocking motherfuckers out. You know what I'm saying? That is a fat couch potato motherfucker right there. Whoa. Irish can be funny. He's an actor, apparently. He doesn't look like that currently. Right. When's the last time you saw him from the shoulders down? Uh-huh. I'm sorry, bro. I'm sorry. So who catfished who, though? That's what I'm wondering, because this motherfucker flew across the ocean to hit it up with shiz. He flew across the fucking ocean. He spent actual money to fly across the ocean to hit up shiz. I wonder who's more disappointed. I just imagine him. She opens the door, she looks at him, he looks at her, and they're both like, so I see you like food. You want to get some apps? Oh, Jesus. Oh, sorry. I'm going to hell. Is it filters? Is Irish using filters? I wouldn't put it past him. Put it past him. Cyrus killed his dog. That sucks. That's terrible. Hi. And cheap ass black wig, egregious. Cheap ass black wig. Is that? I think that's his hair, bro. I think he's just one of those dudes who like has low self-esteem and just doesn't take care of his shit or whatever. So I think how is his hair, man? Damn, that's a big bitch. So they both use filters. I guess so. Thanks. No, I'm not even that shit. Sorry. Dumb Truck was loving the idea till she saw him. And he was probably loving the idea because, dude, like, shiz does not look bad in her filters. You're like, damn. But then you're like, ooh, damn. I wasn't privy to the shiz meeting. He, on some pretext of like defending her honor over her dead baby, go read Turtle Boy's blog on it. Like, or just Google her name, her actual real name. Like, she has a whole bunch of obituaries out there. She was alleging that her child was born and died after her child was born. So there's a whole bunch of fucking lies. Like, it's just all messy. It's all messy. It's all fucking Massachusetts bullshit. But he flew out to like avenge her honor or something like that. And he was going to meet up with Turtle Boy at a bar and kick Turtle Boy's ass. And Turtle Boy works out. And Irish Demon's a fat piece of shit. The Turtle Boy might be small, but he works out. I mean, he's fit. And I'm sure Irish Demon was like, I'll just have a drink with him. And so he talks shit all the way over, meets up with Turtle Boy, doesn't do a goddamn thing and flies back, and then starts talking shit again. Classic pussy. Giant fucking flapping vagina lips pussy. Just, I have zero respect for the dude. And then the bitch movie pulled on when I use the word faggot in his live stream. I mean, just bitch made, rolled over. I'm gonna roll over and fall down to peer pressure. Fuck you, dude. Like, at least pretend like you have nuts. And catfish each other. Did they use filters during sex? Dude, did they? Could they? Is it physically possible? So they're good at camera angles. It's all filters, bro. Or, ma'am. True. Probably went both ways. Mutual disappointment. Yeah, they broke up, right? I'm guessing mutual disappointment. Anyway, that's an old photo. We've got an Irish Demon fan in here. Hard to comb your hair when your arms are so heavy. Good point, sir. Good point. I haven't watched ID for a while. He asks for money too much for my taste. Yeah. Well, I mean, this is how he makes his money. He doesn't actually want to do real work. Okay. He doesn't want to actually do real work. So yeah, he does reaction videos. Congratulations. He has nothing to offer. Anyway, that's it for today. Thanks for watching. Have a great night.